Ladies and gentlemen, the International Symposium on Ethics and Law in the Age of AI will commence shortly. Please kindly take your seats. Thank you. 各位贵宾，大家好，我们今天人工智慧伦理与法律国际论坛即将开始，请各位贵宾尽速就座，谢谢。Good morning, ladies and gentlemen, on-site and online. Welcome to the International Symposium on Ethics and Law in the Age of AI. I'm your MC today. My name is Rebecca. The development of artificial intelligence, AI, is moving full speed ahead, and the future of AI technology is booming. How are ethics and law keeping up with the changes in the age of AI? This is an important question. In order to expand AI development in Taiwan while safeguarding the rights of our people, Taiwan AI COE Promotion Office, the Graduate Institute of National Development, NDI of National Taiwan University, and ITRI organized this forum today under the guidance from the National Science and Technology Council. So today we have invited international legal experts from the United States and Australia, as well as AI and law-related experts and professionals from Taiwan, to discuss how to respond to the challenges of the rapid development of AI and its impact on social ethics and law. And in the very beginning, I would like to introduce the guest of honors and our speakers who are here with us today. Please wave your hands to the audience as I mention your names. So first of all, I would like to welcome Deputy Minister Wen-Tsong Lin at National Science and Technology Council. 我们欢迎我们的国科会林敏聪政务副主任委员。And also like to welcome Professor Jen Yongzhen Xu, Vice Chair of Taiwan AI Center of Excellence, Taiwan AI COE. And also would like to welcome our speaker, Professor Frank Pasquale at Brooklyn Law School. Welcome. And next up, I'd like to welcome Associate Professor Julia Powles at University of Western Australia Law School. And I would like to welcome Professor Ching-Yi Liu from Graduate Institute of National Development, NDI, at National Taiwan University, who will be our moderator today. And next up, our speakers, Dr. Wen-Tsong Chiou from Institutum Iurisprudentiae, Academia Sinica. Welcome. And Dr. Chuan-Feng Wu, welcome also from IIAS. And also our speaker today. Last but not least, I would like to welcome Professor Ching-fu Lin from Institute of Law for Science and Technology, ILST, from National Tsinghua University. Welcome. Thank you all for joining us. And right now, I would like to welcome Deputy Minister Wen-Tsong Lin from National Science and Technology Council to give us an opening remark. Welcome, Deputy Minister Lin.
So our distinguished international guest and speaker, and all speakers here, and all participants who can come so early in the morning, 8:30 right now. So this is amazing. I know how amazing the power of the AI right now. So I think, so I will take off my mask. So I think actually the opening remark of the time is running out according to the schedule. I will make my opening remark shorter. So I think I would like to share first some new approach from NSTC for everyone, not only for our international guests. So we are trying to have the new approach for the so-called core-value-driven science policy. This sounds a little bit different, a little bit strange as compared to our past experience. In Taiwan, we separate the social science and engineering and the natural science very clearly. So you are the physics, you shouldn't understand any common sense in the law system, right? So usually many people make comment on me. If you are a social scientist, you shouldn't know much knowledge about the computer and so on. This is actually the stereotypes in the past of the Taiwan, but we know in many new technology, in particular the renewable energy, in AI technology, actually it requires the transdiscipline domain crossing talk in the future. And we faced also, particularly because of the fast growing and also popularity of the AI applications, we faced a lot of problems, particularly in the complex society. So the social science will be very important, and we should, at the very beginning, to consider many critical issues, such as the privacy and data manager, and also the bias, about the bias coming from the society embedded in the big data. So there's a lot of questions we needed to say, and also the accountability. I think in the past, if you use the big data, if you use the AI, how is your accountability to the whole society? So the technology is not only the pure technology, but also the very critical issue for the whole society. That will create a lot of the cross-domain in the future that we call that's why we build up a system about the AI Center of Excellence. And this is the first international conference after our establishment. I think this year of the AI Center of Excellence. I really hope that we can hear learning from the speaker, in particularly our experienced speaker from US and from Australia. We had already many interesting discussions yesterday. We hope that we can continue the discussion today. I wish you have a very successful conference. Thank you very much. Yeah.
Thank you, Deputy Minister Lin, for the opening remark. The development of AI is a global megatrend, yet it has brought impact on our social and legal systems. Organizing more exchanges like this forum today will help Taiwan connect with the international community and foster more diversified and prosperous development. And now we will proceed to our first keynote speech. Our first speaker will be Professor Frank Pasquale at Brooklyn Law School. Professor Frank Pasquale is an expert on the law of AI, algorithm, and machine learning. He is Jeffrey D. Fercelli Professor of Law at Brooklyn Law School, an affiliate fellow at Yale University's Information Society Project, and a member of the American Law School. So right now, ladies and gentlemen, please give a big round of applause to welcome Professor Frank Pasquale to talk about automated assistance toward more humane benefits administration via artificial intelligence. Welcome. Oh yeah, he's tall enough. You don't.
Thank you.
Well, you may take off your mask if you feel comfortable. Or.
Oh, sure. Okay. Great. And maybe I'll use this, so that's okay?
Yes,
yeah, great.
Or you can walk around as well.
Great. Let's turn it on. Sorry. All right. Well, this is a great honor to be here today. I am so grateful for the opportunity to make new connections, renew old connections, old friends here. I am also just very grateful for the presence of Deputy Minister Ling, of Vice Chair Chiou, of Professor Liu, and other dignitaries and distinguished members of the audience. It's just great to see you here. And today's talk is going to be a talk that's about some of the positive affordances of AI. But before I get into these positive stories about AI, I will give you a sense of some of the dangers and ethical risks, but then ultimately come around to an idea of using AI for good in public administration. So just to start with this talk, oops, there we go. I wanted to give a little bit of background on computation and natural language processing in law and public administration. So with respect to this, there can be some very simple examples, right? Some of which have been launched worldwide, like a red light camera. Relatively easy to apply artificial intelligence or even just automation to realize who has gone through a red light and to penalize them accordingly. But I should note that even in this area, there are some deep complexities. In the US, there are many rules in terms of the type of evidence that a red light camera can be. Whether a person has to attest to the validity of the camera, how well you could challenge the camera, etc. And I talk about these in an article called A Rule of Persons, Not Machines, which is a piece that I wrote about these legal automation about 3 years ago. But nevertheless, despite that complexity, the proof of concept and the proof of use is clear. A next example that I think is more controversial is one I'd call triaging. And this is a bit hard to explain, but imagine, imagine a situation where you have a court that gets 1,000 applications a year, but it can only hear 100 cases. Okay? So it's hard to figure out which case to hear. Well, the idea of the Illetris et al. Article is that it's possible to compare the past cases which won, the successful applications, to the current applications, and to see which of the 1,000 current applications is most like the 50 successful applications from the past year. And this word "most like" is a very interesting word, right? Most, the pattern, most similar pattern. And in the paper, what they did is they compared word by word, and then 2 words by 2 words, and 3 words by 3 words, and 4 words by 4 words, every combination of words in the new applications and the successful ones, right? Only looking for patterns, not for meaning. And that is one of the key challenges in AI in public administration, is that the computer can find patterns, but doesn't necessarily know meaning. And this, if you look at the work of Margaret Mitchell, Timnit Gebru, others who are critiquing large language models like GPT chat, etc., that failure of semantics is a profound one and a really important one that will come up again and again in our conversation. And we critique it. I and someone with experience in computer programming, my co-author Glenn Cashwell, critique this in an article called Prediction and Persuasion in the Toronto Law Journal. And that's one of the things I find most exciting about this field, is bringing together lawyers and people in computer science, people in coding, to try to understand each other's worlds. So that is one of the more controversial examples. The most controversial would be, say, making or justifying decisions on the basis of AI. So for example, in Eugene Volok's work, Chief Justice Robots, he's proposed the possibility that in the future, you could have something like ChatGPT writing appellate opinions of judges. And in a way, this is the optimal use case. It is both the most optimal use case, according to Volok, and the least optimal use case, according to me. But he feels it's the most optimal case because an appellate decision is technically not about any feature of the world to be perceived by a human or machine. It's about text. It's only about words and text. And so the idea there behind Chief Justice Robots, this idea, is that if it's only about text, a computer can process it. And I've worked on an appellate court, and I can say part of our requirement was that we didn't search for things outside the record. We only looked at things inside the record in past cases. But nevertheless, this problem of meaning is a very difficult problem, right? And so I think that is a real issue. And I think that another critique by Maria O'Sullivan, which I've got in the slide, is that the problem also becomes that if there's one small error in the processing or entry of the data, that can lead to many problems. And just to give an example of that, how large should the corpus be in terms of figuring out what law is relevant to a given appellate decision? That's the problem, right? The problem is like we can't just sort of say, oh, there's all of these opinions out there that could be relevant, because a case in maritime law may have no relevance whatsoever to a case in intellectual property law. Someone has to decide the bounds of the cases that are relevant, and that will involve judgment. But it'll be a strange kind of judgment removed from the case at hand. It's about what cases could potentially be relevant to the case. So that's a message of my book, New Laws of Robotics, is that you've always got to have domain experts, like attorneys, assisting experts in natural language processing or computer science if they try to automate administrative processes. Another example, I want to give some examples from Australia that I think are quite interesting in terms of natural legal language processing. I know we've probably all heard about NLP, but there's also natural legal language processing. One is that AI and machine learning can help statute drafters in navigating complicated revisions to laws. You can sort of trace over time how a law has been changed. So that's useful. If we've used tracked changes in Microsoft Word, you've probably used this, this sort of function. So that's a useful function. Another interesting application of plagiarism detection software by Giselle Hill is to compare legislation of different states or countries. So you could use that to sort of say, oh, did this country base its law on another country's law, right? Or is this law based on some other law? So that can be an interesting application, a simple one, right? Some people would say that's not even AI, it's just simple computation. But it's a foundation. And then a third one, but a third problem, I think, is that McIntyre and Olishnik have argued that AI's role should never extend to the core business of judicial determinations. And I think a lot of what we'll be discussing today, having looked at the prior work of our speakers, who've all contributed in very important ways to this dialogue, is what is that core business? And how can we, in a reflective way, avoid over-automating prematurely? It's what the legal scholar Brian Shepard calls premature disruption. We could see disruption, it could be a good thing, but we don't want premature disruption. Now, one of the motivations for this project in AI and public administration is the fact that there's an impasse now, I think, in the use of natural language processing in public administration. And here's the impasse. The idea is that you could use natural language processing to rapidly approve claims. Think about claims for insurance, unemployment, medical benefits, payments, reimbursements. All that could be much faster than it is. But there are so many problems out there with existing applications. For example, inaccurate data or inferences. In Australia presently, there's a scandal called robo-debt and a huge government inquiry into a form of automation that essentially changed the law. So the problem here, and this is a problem that the US has seen since at least the mid-2000s, is sometimes when computer scientists and others try to automate the law, they change the law. And to give a really simple example, there was a rule in Colorado that stated that any person with breast cancer should get government assistance in treatment, but it wasn't programmed into the application. So people would apply and be rejected sometimes, even if they had cancer, and that wasn't part of the system, the computerized system, and there was no easy way to get to a person. So this, I think, is the first problem to look out for, is the problem of translation to computer science, translation to code, changing the law. A second problem is inappropriate data. In the US, there was a proposal that anyone on disability payment who said they couldn't work, that their social media would be surveilled. So let's say someone says, I cannot work because I've broken my legs. The idea here is that if you found a picture of them skiing, on their Instagram or Facebook, you could take away the benefit, right? And on some level, this sounds plausible. Sounds like a good thing to do to stop fraud. But as a lot of people have said, you know, what if they're taking a picture of someone else skiing, right? And it's probably the case that most programs now don't have the sophistication to know exactly who's in the picture. Is it a fake picture? Is it something that was staged, et cetera? You know, so this, I think, is a problem, and it's inappropriate. But even more importantly, even if we perfected the technology, do we want the government to be looking over our social media all the time, right? I mean, we could extend this to taxes, right? There could be all sorts of things where you could do that, or surveillance of all sorts of things online. So that may be inappropriate. Another is what I'd call disguised acceleration of austerity, where in Idaho and Arkansas in the US, they automated the determination of how many hours of help disabled persons would be entitled to. So let's say you have someone who's paraplegic or quadriplegic. They cannot bathe themselves, they can't cook, they can't ambulate, they can't walk out of the house, etc. And they were entitled to 40 hours a week of care. Well, Idaho and Arkansas wanted to give them less care, so they said the algorithm will determine it. And the algorithm determined that you only get 30 hours a week or 20 hours a week of care, right? Someone coming in 4 hours a day versus 8. And then when people challenged it, they were told, this is a trade secret. It's a trade secret algorithm. We can't tell you what's in the algorithm, so you can't really challenge it. You know, and this is a big problem, right? I mean, if we allow algorithms like this to just determine things without opening the black box, that's a big problem. I've already talked about the problem of triaging in a prior slide in my piece with Cashwell. Another would be, I'd say, insuperable barriers to specifying all the possible combinations of meritorious claims. So it's hard to really, for computer science and computers to take account of equity and sort of exceptions. So that's another area where I think it's difficult. And this leads to a culminating argument by Daniel Citron and Ryan Calo that the automated administrative state may be facing a crisis of legitimacy. If you take all these problems together, there's a really stalling of automation in many areas. Even in Europe, and it's interesting to note that, like, I've been comparing the European and American automation processes, and Europe is far ahead. There's a case study by Colin Van Noort of almost 200 applications of AI in public administration in Europe. And there's another parallel book-length survey that's written by Daniel Ho and Daniel Engstrom and some other folks in America that probably only has about 20, 30 examples, right? And I'm not saying either was trying to be exhaustive, but I'm just saying, like, Europe is ahead, I think, in many ways in terms of which you wouldn't expect, right? You'd expect, given the technological prowess of the two places, that the US would be doing more. But even in Europe, there's a lot of questioning now about how far to go and what types of things you can do. And to give one European example, there was actually an algorithm for people that were unemployed. And what the algorithm would advise a caseworker on was whether the person was someone that could ultimately get a job, or if the caseworker should just give up on getting them a job, right? And they weren't told about this algorithm. So imagine having the futility algorithm say about you or a person you know, well, just give up on them, right? And this is worrisome. You know, it's a worrisome and potential stigma of individuals. Ironically, though, this stigma sort of helped them in terms of they didn't have to go out and try to find jobs. And so maybe that's kind of helped them in some ways, but it's, at the very least, should be more transparent. Now, moving on in terms of automated assistance, all of these examples, I'd say, are examples of the difficulties moving from machine-readable to machine-consumable law, and as Moses and others have pointed out. So my question is, why not use natural language processing in a lower-risk situation? Okay? And the hypothetical I'm going to do the rest of the talk on is, what if automation could only be used to help persons, but not to harm them, only to grant benefits, but not to deny them? Okay? And this, I think, is an interesting inversion, because usually the automation is billed as rooting out fraud, rooting out problems, getting rid of the malingerers and people who are shirking, right? But what if we reversed the polarity and said, hey, let's use it to give benefits? I think this could actually be an interesting use case for developing and advancing more natural language processing administration that doesn't have the risks that I described. So what would it look like? Well, let me give you a little bit of background on US disability benefits, and then I'll get into the details here. And I apologize for not knowing the details of Taiwanese schemes in this area. I'd love to learn more. But just to give some background in the US, in a study of 1 year of these claims, only 36% of the million applicants or so were initially successful, but 59% were ultimately allowed. Right? So if you do the math on those percentages, that's about 200,000 people that are qualified, but have to wait 6 or 12 or 24 months, sometimes even 3 years for their benefits. And many times these people are in desperate need, right? And so in these situations, the reason it takes so long is that there's complex fact-finding. When someone has disability, we have to determine what type of work could they do given their disability for most cases, right? We have to think about what type of jobs are available in the economy, and it depends on how high the person's education level is, what's the extent of their disability, where they live in the country, et cetera. In some parts of Alabama, in some cities, 1/3 of the persons are on disability. Okay, because on some level the economy is bad, and so there's not many jobs. So you don't need to be too disabled to not find a job, right? So this is part of the issue. But there is the case of these things called listed impairments, right? And the listed impairments are severe enough to prevent an individual from doing any work regardless of their age, education, or work experience, right? And that, I think, is a very interesting concept. One of them might be someone who's terminally ill with cancer. They might be the idea is we just give them benefits, or someone with multiple comorbidities, et cetera. And so this is a good foundation for a fast track because you have the listed impairment, you get the benefit. Okay, and moving on. Compassionate allowance is another example of this, and quick disability determination. So when we look at these types of scenarios, essentially, with respect to compassionate allowances, these can be some of the most pressing listed impairments. And quick disability determination is another example here. And here, one way in which this is done is you could have text matching software. So we already have text matching software, which could be like a spell check, that can find some of these listed impairments in persons' applications, right? And this is described in detail in this article called Automatic Health Record Review to help prioritize the gravely ill applicants, right? And the idea here, I think, which is quite important, is they're looking not just at the application, but at medical records. Because sometimes if someone is really sick, they may not be in the position to fill out the application well, right? This is a real problem, right? If someone really have a lot of problems, they're facing a difficult health challenge, they don't need to also face a difficult bureaucratic challenge. So we could automatically find some of these things. And there is a specific list of these compassionate allowance conditions. So we know exactly what the conditions are and how to help people, right? And once deployed, the software looks for these. And this is something that was done in the field office in Baltimore. I used to teach in Maryland, in Baltimore, for University of Maryland. And I used to go by this building, where this was done each day. And it was a very interesting idea and helpful idea, trying to help individuals. Now, if you visualize the workflow from the Abbott, Ho, and Erickson article, what you see here is that originally you have a disability application, and you go through certain sorts of string matching, and you could get, in the situation, say, the expedited service. But if you add in the medical records, this provides another source of data that could get you to expedited service. So in a way, we're already seeing, for simple applications, the use of the technology to advance and more rapidly get help to the people who need it, which I think is a very positive advance. Now, another example here is, could we have these compassionate allowances be extended, right? The examples I've given are things like someone has a form of cancer, glioblastoma, for example, a very severe form of cancer. But could we imagine a world where the totality of circumstances indicates a pressing need? Where it's not just one condition that's a listed condition, but imagine someone that has, say, stage 3 cancer out of 4, congestive heart failure, chronic obstructive pulmonary disorder, and leukemia, right? Someone that has 4 problems that may individually not be enough, but you put them together and you find out that 99% of people that had those 4 conditions were ultimately granted benefits, right? That's the sort of thing I think that natural language processing and machine learning could try to identify, particularly because if you look at the international classification of diseases, as we've moved from ICD-10 to ICD-11, we moved from 14,000 classifications to over 140,000 classifications. And I think the permutations of disease type and severity is in the billions, easily in the billions, right? If you think about all these different conditions people could have that could undermine their productivity or ability to work. And so I think this is quite promising to think about, could you have a world where you just run massive amounts of records through natural language processing, where they could say, here are 1,000 combinations where 99% of people always got the benefits. Okay? So that sort of is an idea that and I think that this would be also useful for something called the Fast Track Program for the Terminally Ill. It's called TERI for terminal illness. And the US Social Security Administration orders field offices to flag these cases using this electronic TERI flag. By the way, this prediction of death is something I work on in my book, New Laws of Robotics, and I think it's very useful in many areas, but also quite controversial, right? In terms of like, if you have someone, let's say, in the intensive care unit, and you have only a fixed number of ventilators or other advanced medical equipment, do you use algorithms to predict that someone has no chance of recovery to say, stop the treatment, right? I think that is something on the horizon that should only be used, though, under the supervision of a doctor, and also should not be used in insurance settings to decide whether to insure someone or not. It should only be a professional decision of the doctor, but we shouldn't allow, I think, either the state or private insurers to say, your recovery score is less than 1%, we're cutting things off. But that's going to be a huge issue in the future, I think, especially as we have more pandemics, more situations of extreme healthcare need, et cetera. But to come back to our topic, here are some of the exploratory programs at the SSA that I think could feed into my idea. I should note these exploratory programs, though, are about both granting and denying benefits, where I'm just about granting benefits. Call me Santa Claus for Christmas, right? I'm all about just sort of giving people benefits. And some of these involve using certain language as being indicative or not indicative of disability. And some of this basically comes down to the possibility of scoring. And I want to give you this one example that I think is quite interesting about the conversion of language to numbers and quantification and what we think about it. So here's an example, where you could code for polarities, okay? So imagine that you have a situation where you're trying to find out if someone is disabled enough to get the benefits. And we have in their record, it's undisputed, that essentially it states the patient ambulates, which means walks. They walk with a front-wheeled walker for 300 feet. Well, and imagine that there's sort of a number of points for disability, right? And that you have 100 points, you're disabled, right? And this is one of many statements about the person. Well, in this context, the fact that they walk, that's going to have a polarity of able. So we could imagine that they lose 50 points, right? Because many people who apply for disability cannot walk. And so let's say they lose a certain number of points for that disability. But this ability is qualified by the modifier with a walker, only 300 feet. So these modifiers might say, reduce the loss of points to say 25 points and then to 10 points or something like that, right? You could just imagine different ways of trying to quantify the determination. Now, I don't think this is a particularly good way to make decisions in the cases. And we can discuss why that's a problem in terms of like a point system. Because I think that the legislature never made a determination as to, with that level of specificity, right? Nobody in the legislature actually figured that out. There are some situations where legislatures do try to have that type of specificity. For example, in rationing medical services in Oregon, they rank ordered all medical services and then said, we'll cover the first 400. Okay, so that's one way in which a legislature did that. But in general, like, legislatures don't think this way. And I don't endorse making them think this way as to the entire benefit scheme, because I think it's just too hard to figure out exactly what the polarity value should be for any given ability or inability. And I think there is a cause for holistic judgment there. But I like being in dialogue with those in computer science that would try to do this, because if you think from a simple administrative cost perspective, you'd save a lot of costs if you could assign point values to every form of disability and modification of the disability, right? And I predict that in the future, we're going to see exactly this type of pressure on social services administrations. We're going to see the pressure to say, what we want to see is this sort of reduction, a form of reductionism of values to quantified terms that can be handled algorithmically. And my proposal today is that essentially what I want to see is the possibility of having this used to grant benefits, but not to deny them, okay? That's where I think it could be used. So if we, even though I would not replace the entire benefit system by something like this coding for polarities, what I would suggest is that what we can find the top 1%, 5% of cases that are the most challenging. There are people where there's the most similarity between those that have won in the past, and that those are granted in an expedited process. And what that also does is it frees up more time and resources to consider the other cases more carefully, right? So that is where I'd say now the question becomes, of course, is it the 1% neediest? Is it the 5% neediest? Is it the 10% who are the most disabled? That's something we can discuss, in debate. But that's sort of where I would be going with this. Now, the final slide that I have, I think, for today, is, interesting. I hope I didn't break it. There we go. No, that's it, not it. Where should I point it? I'm sorry. It worked for so long. I'm just trying to get to the final slide. There we are. Oh, that's it. I got it. Thank you. Thank you. Sorry about that. So I just want to talk about just 4 objections to my proposal, which I think would be helpful, right, to think about. One is that, you could characterize this as automated grace. And by the way, I should ask, am I out of time, or is it 1 minute? Oh, good. Okay, good. 5 more minutes. Okay. Yeah. Thanks. Sorry. I just wanted to be sure to say that with respect to anticipating the objections, one is that you might say, is this a form of grace, of sort of discretion that does not abide with the rule of law, right? Because these programs, when I mention, the pattern matching here, there may be no explanation for why the pattern matches. It's just the pattern matches, right? And in law, we usually demand an explanation. So is that a problem, right? And here I think that perhaps similarity of present applications to past successful ones could be seen as a form of evidence. And this idea of what is evidence in law is so interesting. The judge and professor Genevieve van der Stichel, she's written a wonderful article called The Normative Value of Legal Analytics on Statistical Precedent. And her idea is that you could potentially think of this as a form of evidence. She doesn't think of it as being like evidence from the real world, but it may be thought of as kind of a quasi-evidence of what a court should do. So that's one way of thinking about this. The second is consistency objections, right? Is it consistent? When we think about discretion or grace in a scenario like this, that almost seems like an aesthetic or a religious concept. But for the grace of God go I, or something like that, right? Or just a pardon, like a pardon by a criminal. But I think that there's concepts of prosecutorial ministerial discretion in every situation, right? Tim Wu, a big figure in the Biden administration now, who's leading the issues on competition, he's written a wonderful article called Tolerated Lawbreaking. And that's an issue where I think that, we live in societies where we don't necessarily enforce the law against everyone. And so potentially it's plausible to have a grant of discretion in various scenarios. And I think the opposite veers toward a society of control, as Cashwell and I argue in this a piece called Four Futures of Legal Automation. So we don't want to go in the opposite direction. A third would be the core function objections, would be that AI's role should never extend the core business of judicial determinations. Given the time, I just want to skip that for now, but I think that if it's only 1% of cases, maybe that's not the core, maybe that's the periphery. Okay, so that would be my response there. Finally, public budget objections. Again, I think if it's 1% of cases, it doesn't necessarily break the budget, but we can think about the extent to which it could deny funding to others, and is that fair or not? And that could be a problem. My final slide actually is almost there. There we go. And this really is a lesson in the problems of automation and computing, isn't it? But I think we've got 4 futures of benefits automation ahead, okay? And one, which is what I have described in this talk, is in this upper left-hand corner, right? That we could have rapid automated identification of urgent and valid claims, and that could inform future developments in student loan debt forgiveness, approval of benefits, and smaller aid programs like black lung benefits. We have a lot of miners in the US that their lungs have been blackened by coal and soot, and they need benefits. And sometimes it takes 25 years to approve benefits for them. Many of them die waiting for benefits. So given that urgency, we may want to do this. But I think we could also see a set of rules, right? Just where essentially everybody's debt is forgiven or everyone's given benefits, et cetera. But that probably would break the budget. So I think that's a hard box to be in. Automated inequality by Virginia Eubanks, she's talked about slower and more restricted the problem of slower and more restricted benefits by more automated systems, which I think is quite a profound critique. And then finally, our current situation is protracted adjudication. So even if you think my proposal is a little utopian, I think it's better than the other 3 boxes. So, that's what I'll leave you with. I really look forward to the discussion today, and thanks so much for your interest and attention. Thanks.
Thank you so much, Professor Frank Pasquale, for your informative presentation. Thank you so much. And I will introduce our next speaker a little bit. Our next speaker will be Associate Professor Julia Powles at University of Western Australia Law School. And Associate Professor Powles is also the Director of the University of Western Australia's Minoru Tech and Policy Lab. She is an expert in privacy, intellectual property, internet governance, and the law and politics of data, automation, and artificial intelligence. So ladies and gentlemen, please give a big round of applause to welcome Associate Professor Julia Powles. What do you want to use, the hand mic or these? Either one. Should I use that?
There we go. Thank you so much. I'll really give my acknowledgements first. It's an absolute pleasure to be here. It's my first time to Taiwan, and I've been so impressed by, I think, the dedication that the National AI Centre has to ensuring governance of AI systems, and I think there's really tremendous opportunities. And in preparing for this event, I was really struck by the opportunities that we have in Australia and in Taiwan, and how common they are, in fact. And so I wanted to take the invitation of the Deputy Minister and our distinguished professors to really use the opportunity today to be thinking about where Taiwan can learn from international experience, and some of the opportunities to jump ahead, I think, from debates that otherwise can be quite distracting. Oh, sorry. So in particular, the topic that I really wanted to get into is a paper that's forthcoming about big tech culpability. And I'll give you a bit of an introduction about how I get to that topic from a conversation about governance of automated decision making. Like Frank, I'm really interested in how we can use the energy around conversations of AI governance to really make advances that are in keeping with other considerations, particularly the societal considerations that I think have been so pronounced in the introductory comments today. So, I'm sorry, we had a couple of little slide challenges, so I trust that this will all come through fine. So what I'm going to do is, in two parts, I want to spend some time at first thinking about governance of automated decision-making, and in particular, some concerns that a lot of the energy I've observed internationally is reinventing protections that we have in our legal systems, and that we can think of some strengths in that reinvention, but also some opportunities to go ahead. Because it may be the case here that it's similar to the experience that I've had in any country that's not Europe, frankly, which is that there's a lot of caution about how we can respond to automated systems, and perhaps some intimidation about what a country that has a relatively small footprint, internationally speaking, can do about big tech systems. And from that, my work in thinking about governance of automated decision-making from a government level has led to thinking a lot more about governance of automated decision-making from a corporate level. So the second half, I'll really spend some time in thinking about the ways that we can and should respond to corporate use of big tech, of automated systems. So there are two key debates that have occupied a very significant amount of attention in thinking about AI and automated systems. The first is, and it was mentioned in the opening comments, the debate about artificial intelligence bias. And if I connect that to our foundational considerations in administrative law, that connects to a consideration of our long-standing concern about decisions that are capricious, arbitrary and unreasonable. And we have, in your jurisdiction, in mine, many jurisdictions around the world, protections around such decision-making. We have those protections because they are against our ideas of autonomy, and they're against the sort of society we wish to live in. As that long-standing administrative law debate has translated to a digital context, there's a few things that have been lost and a few things that have been pushed to the side. And so in the spirit that I was invited to speak today, I want to give some provocations about what we mustn't lose in translating a long-established principle to the digital reality. The second biggest debate that I see is a debate about the right to explanation or to have an ability to understand automated decision-making. And that, from an administrative law perspective, connects to our long-standing administrative principles against unjustified decision-making or incontestable decisions, so that you would be subject to systems. And I think the original examples that Frank led with are those sorts of systems that could be used in a way that deprive us of that ability to have justifications, reasons, and contestability. And he mentioned, and at the moment in Australia we have a major royal commission that is looking at a great instance of decision-making that was unjustified and incontestable. So people over a number of years were exposed to decisions that led to them being told, you have debts that you need to repay to the government. And that came in automated letters that said, this debt is outstanding, it needs to be repaid. And it was only after there was an internal investigation and people were saying, why this doesn't seem right, that it was revealed that there was an automated system that had an inappropriate way of deciding whether or not someone had to repay a debt. And this had very human consequences. There were people who were put into depression, there were instances of suicide. It was really dramatic. And it led to billions of dollars being repaid by the Australian government in response to this. And now to an inquiry that's really looking at how can we reconsider the way in which we make decisions about the use of automated systems and how we explain them. And I'll just say this particular system failed in those ways, and it was a very simple system. And one of the reasons these two debates so occupy our attention is because AI can be a very complex system, but it can also be very simple. And I think that the first thing I'd say about these debates is that they collapse complex systems with simple systems. My impression is that only a tiny fraction of automated systems in use are in the category of systems that are too hard even for the designers to explain. And even if the designers can't explain how they reach a conclusion, they can certainly say what they were trying to achieve in creating the system. So these two debates, why are they problematic to only focus on AI bias and the right to explanation? I'm going to give what I think we lose, and I am doing this deliberately, provocatively, if we only focus on those concerns and what we might be missing and where we could see some further opportunities. So with the philosopher Helen Nissenbaum, I wrote this piece a couple of years ago about the problems of zeroing in on AI bias, and I think they really still persist today. And I think it was wonderful, Professor Ling in the opening comments making this observation that bias is a social problem. So AI systems, automated systems, learn in very simple terms from huge data sets of information of things that have gone before. And in learning from those huge data sets of information, they learn about the society we live in, and the society we live in is rife with bias. So they're learning from social systems that have bias, and recognising that there is obviously a much broader set of tools that we might have in responding to the causes of bias than just technical ones. And I think the previous talk really gave an indication of the broader context into which we're resolving situations like benefits. There are much bigger systems, and then the piece of this which can be solved technically is only one part of the puzzle of how it is that we have a problem like bias in society. The second, and this is a really important one, when we respond to bias technically, one of the solutions that's very common is, for example, when both Professor Pasquale and I have worked a lot in health. In a health context, for example, we're building a system to diagnose a particular skin condition, and it turns out that it's learning from a data set that has only a certain demographic of the population. So the natural response is, well, now let's include many more demographics of the population. And in a health context, I can get on board that solution. But now let's take a different example. We're now looking at systems of surveillance for national security purposes. And suddenly we've got a situation where we are creating surveillance systems to fix the problem that they're not representative and extending surveillance systems that cause the problem of surveillance. In effect, creating systems that put everybody into situations where they are more machine readable and subject, therefore, to the potential arbitrary rule of digital systems in order to fix a problem that they don't apply to everyone. Now, when this manifested in the famous debates about the use of automated systems in the US that were very poor in relation to African Americans and particularly women who are African Americans, the response was maybe we shouldn't fix a system and say it doesn't work. There's a reason that this system should not be applied. So I think that retaining a possibility of saying, instead of fixing the system by subjecting everyone to the system, there's also the option, always, to say, let's not apply the system. And so that connects to this third point, got jumping ahead slides, apologies. This third point, that by focusing on bias, I think it's a very deliberate conversation that has been led particularly by industry, because one of the things about bias is we can't get rid of it, and it's a feature. And so it becomes one of those problems that is very useful to admire and very useful to put as our primary concern, and to distract us from, for example, who is developing digital systems, what oversight and accountability do we have, and how's the trade-off between who's benefiting from applying a system and who's not benefiting. All of those bigger questions get put to the side because of the really insoluble problem of bias in systems that are learning from biased information. So I think that I'm not saying that it's not an important concern, but it's really an opportunity, I think, for countries that wish to do something sophisticated with AI governance to go beyond just a consideration of bias. That's my first key point. And it connects to why I think if we go beyond bias, we have real opportunities, because really what we're concerned about with bias goes back to broader concerns about capricious and unreasonable decision making. And so really we need, instead of fixing the inputs into data systems, we need to have genuine accountability mechanisms that are external to the companies or governments that develop them and are accessible to populations. And I've recently been doing some advisory work on responsible AI, which is what the current Australian government is leading. And what I've noticed is that there's such a desire to respond to AI challenges with technical solutions. And it's much harder to have a conversation about how do you have systems that enable those systems to be responded to in a way that is contestable, accountable, and offers mechanisms for redress. So the robo-debt example is one of those playing out on a public stage, well overdue, and there are so many systems, I think, that also have this requirement that we need to be able to understand the mechanisms by which automated systems operate and have the possibility of contest. And I'll talk in a minute about how that connects to right to explanation. But there's also this very important point, and it really comes through, I think, in the work that is being led by Professor Pasquale and others, that it also is important to have the prospect sometimes to not automate solutions. There are many contexts in which a predictive system doesn't result in the best outcome. And in particular, when we have appreciable social costs, and this is it may be part of your industrial policy here, part of our industrial policy is to increase the use of AI. And what we're really trying to do in the Responsible AI subcommittee is to say, well, we want to increase use of demonstrably beneficial AI. And that doesn't seem too hard an assertion to make, but I think it's still a very big challenge for governments and for industry to recognise that that is something that people expect and something that people should also require. So the second thing that I think people should expect and require is the ability to have an explanation. And this is a debate, and I'm just going to give you a snapshot of a debate that I wonder if it's playing out here. I've spent 12 years in Europe, and in Europe there's this very significant debate about whether or not the European data protection law, which is the origin of over 100 countries' data protection laws, has a right to an explanation. And in very short form, because the law doesn't have a provision that starts with the words right to explanation, it's created a very big academic debate and hoo-ha about whether or not it does have an explanation. I responded to this with my colleague Andrew Selpst in a piece that read the legislation itself, and in particular read provisions that said, and this actually comes from 25 years ago, the origin of the data protection regime in Europe, that the existence of an automated decision needs to be made known to people, and meaningful information about the logic involved, as well as the significance and consequences for an individual. And what we argued is that that is a right to explanation in all but name. It is a right to have meaningful information. Importantly, and I actually think there's a real opportunity in the fact that it didn't spell out more precisely what the explanation should be, because the explanation needs to serve other elements that are the spirit of data protection law and privacy law, which is that one needs the right to be able to functionally, flexibly, and with meaningfulness, exercise your rights. So any system which enables oversight and review of decision making that affects someone's rights requires that they have functional information. And I love that it's a very flexible definition, because I'm sure that the computer scientists can see that rather than getting caught in the detail of how magnificently complex automated systems can be in their operations and workings, there is an explanation, and I think we'll hear more about this, that is externally facing, which serves the objectives of the person who the decision is made about. And I offer this as a snapshot because I think Taiwan and other countries that are thinking about how to have a really productive regime should be confident in taking core reasonable ideas like we need a functional and flexible way of giving people information in a way that's meaningful to them, and that's both instrumental so they can exercise their rights and intrinsic so we're not subject to systems that make you feel like you're in a Kafkaesque reality where things happen to you and you don't know why. And I've observed that there's this particular preoccupation with carrying forward the language of legislation like the European data protection regime and not carrying the spirit of those rules, like meaningful information that gives you the significance and can be acted on, but actually all of the baggage of the debate about, is the language saying that in the title, is it in the functional part of the act or in the recitals? Lots of artefacts of legal debate. And we have the opportunity to fix those, to say, well, yes, we think if a decision does have impacts on an individual, that it should be explained. And so there's a lot of simplification that can be done in sort of going back to what is the spirit of these rules. And I do think there's a lot of international experience now that enables that. And just as another sort of point of reference, in 2007, Australia had rules about automated decision making, and they offered exactly these same sorts of principles. And in the Robodebt inquiry now, they're going back to, we actually thought of this well before the age of AI, and we had principles that required things like a reasonable, informative explanation in a way that's actionable by individuals. So I've given two debates that I think take us in a certain direction and that we have some opportunities to go beyond. I'm just going to offer two ideas that I think are not being discussed and are profound challenges from a public law perspective. So the first, and this continues to exercise me, and I'm surprised there's not more attention to it, is, and this is a little DALL-E image of an interpretation from a large image model of what I'm talking about. We anticipate and expect in our legal system that what we do in the world will have consequences and not what we don't do in the world. And the shift to systems that are based on prediction is that they are informed by not what we do in the world, but what people like us do in the world. And I think this is actually the core of why the box that Professor Pasquale left us with is the only box that we could choose, because it's the only box that recenters the individual in the consequences that arrive for them and prevents the capriciousness and the unjustifiability of consequences that are not about them. So I think this is a really central consideration. So effectively, if you are of a certain, some of those examples, like if 5 people, that you could hone in a system to a certain number of people in a predictive capacity, I think if that system means that certain people have their rights limited, That's a really profound challenge that is different to how we have always centred our legal system around cause and consequence for individuals. So I think that really deserves some robust thinking, and I think that debates like bias, which really are very familiar to people who work in administrative law, this is a challenge that we've never had before in our public law system, and it's a challenge I don't think we're equipped to deal with, and it manifests in systems like the automation of inequality. And the second, and there's this traditional bifurcation between the protections we have around when the state makes decisions and when private entities make decisions. And so these ideas I've been talking about come out of restraints on executive power of the state, but the same controls and incentives don't exist for corporate entities. And so they present, again, a real challenge when so many of our public systems now depend on complex relationships with private and public entities. And I hadn't quite appreciated how significant this challenge was until doing work with in our national government with thinking about the AI industry and realising that any sort of requirements like explanation or accountability almost required that those companies voluntarily decided it was a good idea. And that puts us in a very weak position because it is not, there's no incentives really to expose one's systems. There's also no incentives on government. Part of why systems like the Australian robo-debt example persist is because there's a lot of, there's concerns around the secrecy of those systems, and there's even some embarrassment about their design and inadequacies. So it is a profound challenge that we at the moment have settings that say that corporate entities exercising decision-making power, we really only have tools of incentive and voluntariness to require them to provide, I think, very foundational and fundamental rights to individuals. So the second half of what I really want to talk about is how do we get some more of those tools in relation to corporate entities. So I've done this paper on the corporate culpability of big tech, and it's motivated by some of the horrendous stories that we read all of the time about the dangers and damage that are caused by companies like Google and Facebook and Amazon. Instances like slave markets and human trafficking being occasioned across Facebook's platform, misinformation, disinformation, hate speech, violence. There was a massive, the Facebook files which were revealed by the Wall Street Journal last year, where internal researchers at Facebook showed that for 1 in 3 teenage girls, they were put in a position of suffering depression and body dysmorphia from using Instagram. So services that have profound societal consequences, and that the response of our political establishment is often to really be in this exercise of encouraging better behaviour, but not having many tools to require better behaviour. And so I took some time to look into why it is that big tech companies in particular have been so successful in having very small liabilities despite their size. And there are a few key reasons. One is about jurisdictional and regulatory arbitrage, and I think this is very profound to talk about outside the US. So entities like Google and Facebook and Amazon exist and centre their operations in the United States, and they exploit a particular legal structure that means that the activities that they operate, that they conduct nationally and internationally, benefit from immunities, which mean that they claim to just be the neutral platform in which all of this conduct, the hate speech, the human traffic and so on, that just persists over the top of their platform, and they are not themselves subject to legal consequence. And the practical effect is that, for example, if in Taiwan there was an instance of a tragedy that occurred and it was occasioned by a company like Facebook, their first response would be, if you wish to bring legal actions, you need to go to California. And then you go to California and they say, we're just a platform, we can rely on this immunity. So you're caught without a remedy. They also insulate themselves in being sort of exceptional, that they're exceptional in the innovation and the disruption and the economic growth that they promise. And in countries that are not receiving that economic growth, we should question, I think, some of that narrative. And then the third, and this is something Professor Pasquale has written about, is that these companies make their own markets effectively. They exist like social media outside traditional markets and therefore exist outside the traditional protections we have for industry, especially around standard requirements that to operate a business you need to engage as a fit and proper person. And so they evade some of the systems that would otherwise require and enable the state to impose requirements on them in a way that keeps them to be reasonable operators. So the second part of that challenge that buttresses all of those is that we have this real challenge with dealing in this with companies and the corporate mind. And so the traditional rule of establishing corporate culpability is that the directing mind and will of the company needs to have engaged in and be knowledgeable about misconduct, and that any other part of a business is just the arms and legs of the company doing the corporate mind's work. And the particular theory that I rely on to get closer to the culpable corporate mind is a theory developed by Professor Elise Bant, which recognises that we now have massive, complex organisations where it would be rational for directors to not know about things and for those arms and legs to go off and do things that are, in fact, misconduct. And that it would therefore not be a rational response to say, well, only the corporate mind and will, only the directing mind and will is the part of the entity that leads to culpability. We need a new response. And her core insight is that the best way of knowing how a company thinks is what a company does. And in particular, in companies like Facebook and Google, which take advertising revenue and do not do classic know your customer checks that any other financial entity would do, that do not respond when they see that there's conduct and are notified about conduct that involves criminal offences over their platform, if that company systematically does not act on that information, that is the manifestation of corporate intent. And a thing that particularly struck me in thinking through this model is, because it's hard to get at the corporate mind, we haven't thought enough about the modes of responding to technology companies that, for example, have to volunteer to give you information through the lens of intent. And the intent, quite rationally, that they preserve is that there is no reason for them to explain and to operate. If they do explain to people how they are behaving and they do apologise, as Mark Zuckerberg does, that's just their own pejorative. It's not actually something that they're required to do. And because we haven't thought enough about intent or had a legal mechanism of responding to intent, it means that the responses we have really feel very inadequate. So in the US, the biggest fine that the FTC has ever given came to Facebook, and it made back the same money, $5 billion, in the same afternoon. So we have chump change remedies that are really not a disincentive to operating in a way that is about misconduct at scale. And if we had mechanisms of responding where we could respond with corporate intent, we would be able to access ideas around duty of care, we'd be able to access systems of criminal conduct, and I think we'd have many more levers to respond to decisions at scale that are not justified, that can be capricious, and that have genuine human consequences. So to really frame this, so this is the theory of systems intentionality. It essentially says the corporate mind is comprised of the systems that are the repeated practices on the ground, and big tech is full of these examples, so rich in examples of conduct that has been flagrant in disrespect for legal systems. And then the intention is what a company intends to do is what a company does. A very simple idea. We can't know, it's a fiction to anthropomorphise a company as if it is something human-like with a mind. A much better way of going is it is the manifestation of the original artificial intelligence that is the corporate structure. The legal person that is a corporation is, I think, a very good model of what an artificial intelligence is, with the sole objective of shareholder value. So the application of this idea of systems intentionality is that by training our attention on the systems that big tech uses every day, I think we can lay bare what is this recurring frustration that they have an expectation and tolerance of the systematic production of collateral damage as just a necessary part of their operations. And it flips that from being an unfortunate consequence to being the manifestation of corporate intent. Instead of it being an argument that we permit that a company says, unlike any other company we permit to operate, we are simply too big to manage the damage that we cause, we flip that and say you have an intention, and in fact it's been applied to some of the mining companies in my country. If you are causing something and you claim system error, that is your systems operating exactly as you designed, exactly as you intended, and therefore consequences should follow. So stories like these ones from the Facebook files about the fact that employees raised issues about misconduct and the company itself did not respond. So both the major stories from last year about the instances of the toxicity of Facebook for teen girls and about human trafficking were long-term known consequences of the platform's operation, flagged by employees and not responded to. So that's a system of conduct, of having practices that would breach domestic jurisdictions, laws around the world, enabling that to continue and not making changes. And Facebook is a bit of a punching bag internationally, but I thought I'd apply and have been thinking about the company Uber, because everywhere I go, it's this ubiquitous platform. And there's something about Uber that has always distressed me, that it's acquired the position it has through a particular mode of operation that I think is very dangerous more broadly in our society. So in particular, the system of conduct by which Uber has operated, and it's revealed in the series about Super Pumped and the theory of Travis Kalanick, was to launch in cities in a way that ensured maximum supply of Uber vehicles, and to do so before any possible market competitor. And the only way that was possible was for all of those vehicles to be launched in breach of domestic rules about licensing. So taxi and private car hire industry, however you want to regard them, have requirements, and two of the key requirements are around safety checks on drivers and around certain societal conditions that we expect. For example, that taxi drivers do a certain number of disability pickups in a given month, that they have annual checks on the security of drivers, that they have mechanisms that are peer-related in terms of review. And so by evading licensing requirements as a business model, and there's documentation of this being the business model, without consequence, there's a precedent, I think, a very dangerous precedent, that to succeed as a contemporary business, you need to grow too big to regulate, and you need to do so in breach of the law. So I take the Uber example as much bigger than, are there conveniences to Uber? Yes. Are there advantages over the taxi industry? Yes. But is the way in which they acquired their present position something that we would want to be replicated in other industries? And the example I would imagine is, imagine a disruptor, we've thought about COVID-driven innovation, that didn't go through the processes that the providers of health services went through in providing healthcare responses in COVID. Imagine if we'd had a disruptor that said, we don't want to go through any of your health approval processes, any of the clinical trials and so on. We're just going to launch this direct to the public and ignore any of your licensure. We would not tolerate such a model that interferes with the lives of people. And I think the example of Facebook's particularly pertinent in that the human toll of systems like the human toll of instances of depression and body dysmorphia are as significant as launching pharmaceuticals in a way that evades a regulatory response. These couple of headlines here I think are really revealing. So the violence guarantees success related to the response from the CEO of Uber when taxi drivers rioted in Paris about the launch of Uber's services there. And the response was, and this demonstrates the impunity of these companies, that the violence of those taxi drivers was a benefit to the promotion of the company's brand, and that there would be no consequence, just as there was no consequence. Similarly, that second one, a kill switch. Imagine a company that designs a system so that when regulators come to investigate, they flip the whole system and show you a decoy version of their operations. The final one there is about the lobbying governments. Extraordinary writing of rules in the rooms of those who were in charge of decision-making, under threat that Uber, and I've seen this a little in the national debate here, there's a direct conduit from these companies, Uber, Facebook, Google, to citizens, and they mobilise those citizens against public officials. So Uber has mastered this around the idea that drivers are sole traders, and that citizens have a right to a efficient ride and so on, and dare a politician intervene in that and say, well, we have licensure systems and these companies are evading it, they will unleash the wrath of citizens onto those public officials. So they really hold this threat. And if we don't respond, I think, to a number of these features, that if you substitute the company Uber for any other entity providing public services, you would, I think, be deeply concerned. Then I think we set up a precedent that has no real response. And this is currently playing out in a fascinating case that gives me a little hint of what would happen if we had more actions that utilise the notion of corporate intent manifest in big tech systems. There's a case in Australia led by a consortium of taxi drivers and unions around the way in which Uber launched its service in every Australian city. And in particular, they argue that it was the tort of conspiracy to launch in a way that evaded the regulation. So it gets at this meta issue of companies that operate as a business model in breach of legal requirements. And this is a finding from the judge that a clear consequence of how the company launched was that ride-sharing offences, so breaches of multiple domestic laws, were committed systematically and at a large scale, and that it was an integral part of Uber's business model. So a direct finding based on troves of evidence in this case, and it repeats internationally. This is not really an exceptional case, it's just one that happens to have been brought to the courts, where these companies have this practice, which I think is a really galling one, of operating in a way that has a business model of legal defiance. An element of this, and Uber's sort of interesting because it's a little bit in this camp, is that without tech companies in making their own markets really operate without our typical requirements around, and I mentioned the health industry, around licensure and regulation. And in so doing, there's a presumption that their operations are legal and that they only need to be investigated in cases of wrongdoing. And I think that what I want to end with are some of the really easy and important foundations for being able to bring these companies that have embedded recklessness by design to heal in countries like Taiwan, where any country in the world should have the ability to respond to entities that are directly influencing the lives of their citizens. And so the three, from this idea that licensure is a useful tool, I think the first, and this was remarkable to me in investigating, particularly in doing some strategic litigation advice, Facebook and Google, in that I gave the example of how they use Section 230 to immunise. So you go to sue them in Taiwan and they say, sue us in California. Only one country in the world, Japan, has a rule that requires that providers of digital platforms in that country must be registered. And having a registered entity instead of relying on a company that is founded in California and providing its service to that country means that you can then respond with the force of the law like you would in any other industry. So I'd really like to see every country have requirements around registration of these entities. And what's wonderful about it, I mentioned how these companies are so sophisticated in mobilising the public against regulation. And how they do it is to say, whatever regulation is coming, this will take something away from citizens. It will change their internet experience. But requiring that a company that provides services is registered is an apolitical requirement, I think. So it's not able to be attacked with the same vigour as anything that is, for example, like your recent proposal built on the German one around mis and disinformation. The second, if you're registered, is that then you can have systems of licensure, and I referred to Professor Pasquale's work on that, where there are positive expectations of, and in conjunction with something that is at the government level, you could also require that providers of common services operate under common expectations. And then I think the third is, if you have registration, you have licensure, then you have the tools to be able to bring any of a creative array of legal responses that we would expect of any other industry. And I think it's high time we have in the big tech context too. Thank you very much.
Thank you so much, Professor Powles, for the fruitful presentation. And after we heard from the two experts from Australia and the US, now we're going to hear some insights from the experts and professionals here in Taiwan. And we will have three speakers from Taiwan. First of all, I would like to welcome Dr. Wen-Tsong Chiou from Institutum in Iurisprudentiae at Academia Sinica. And he will be talking about two types of AI models and their explanations. So welcome, Dr. Chiou.
Good morning, everyone. Deputy Minister Lin and the distinguished guests, Professor Pasquale, Professor Powell, and many professors here. I'm honored. Oh, my mask. Okay. I'm honored to be here to give a 10-minute talk. So comparing to Frank and Julia's job, my burden is much less. Okay. As many new technologies bring the gospel of civilization and progress, they also cause many social unrest. And I think AI is no exception. While AI makes possible the fourth industrial revolution, it also raises great concerns that AI is developed and used at the expense of the value of democracy or human rights. So currently, there are two commonly held approaches that are proposed to combat the dangers of AI application and make the AI more accountable, just like Julia mentioned earlier. And one is human control. The human control demanding that there must be a human in the loop of AI application or decision making, so that human can still have the control over the AI systems. And the other one is to require explainability of AI system, so that we can to make human control possible and provide opportunities for those who are affected to challenge, to contest the AI decisions, and in turn for AI system to justify itself. But what do we really mean by explanation? What do we ask an AI system to explain? Let's do some thought experiment. So, can a 5-year-old kid explain how he or she can tell cookies from chihuahuas? I think any 5-year-old kid can tell the two from each other, but can they explain why they can do that? I'm not sure whether they can or not. Okay. And this is the ability for image recognition. And maybe you can ask a lawyer who passed the bar exam and explain how he or she answered most of the bar exam questions correctly and became a lawyer. Okay, I'm not sure whether Frank can explain or not. How did you do so well that you passed the bar exam? Okay. And can Steve Kirby explain how he can make so many three-point shots? I think okay, here are some pictures for you to see my thought experiments. So, does it really matter if they can do the same without explaining how they do it? And does it matter if someone else can do the same without explaining how he or she did it? And let's think if there's an image recognition AI that can, whoops. Okay, here we go. If there's an image recognition AI that can tell between the dog, the car, the apple, and if there's a question answering system that can answer a question like a lawyer can answer, and if there's a robot, Toyota actually make one, is a basketball playing robot who can make the three-point shots like Steve Curry, do we really need them to explain itself before we recognize that they can do pretty good job? Okay. To answer the questions, I would like to make a distinction between two types of AI applications. The first type of AI application is what I call the emulation AI. The main job for this type of AI is to emulate human behaviors. For example, to recognize different images or do a more difficult job of diagnosis of the image of maybe the X-ray or some functional MRI image. And the other type is what I call the correlation discovery AI, or what Julia calls the prediction-based AI. The main job is that they will try to find the association between some factors that we never noticed before. So this type of the correlation discovery AI can predict if somebody is pregnant by seeing whether they are using unscented lotion, or if somebody is a good has some good credit scoring if they bought the predicate path for their furnitures. And for those two different types of AI, the purposes are actually different. For the first type of emulation AI, the purpose is simple, to make things more efficient. They are looking for efficiencies. And for the second type of AI, the goal is to do some advanced control. And after knowing these two types of AI application, I'm going to make another distinction between explanations. I think there is internal explanation and there is external explanation. By internal explanation, I mean decompositional explanation of internal structures, logics, numbers, or math of the algorithm. And by external explanation, I mean by either you can provide the correlational or counterfactual explanation for the factors, for the variable that would have changed the result of the algorithmic decision. Or there is causal explanation for this external relation between X and Y. If X can predict Y, the occurrence of Y, a causal explanation is needed to account for the relation of X and Y. So my concluding remark is that for emulation AI, because human thinking or behavior is the benchmark to assess performance of EAI, emulation AI, no external explanation is actually needed to justify the acts of, or the thinking of or the decision of the emulation AI system. And when efficiency is the main reason for using this type of emulation AI, what matters for human control purpose is accuracy and reliability of its performance, rather than provision of any internal explanation of the structure of the number of this software. But for association discovery AI, when no pre-existing ground truth can be used to guide the development of ADAI, at least one of external explanation, either is correlational or causal, is needed to justify advanced control effectuated by this association discovery AI systems. And when association discovery AI advanced control decision involve legal or similarly significant effects, or in Julia's word, is appreciable societal cost, if involving that kind of cost, then causal explanation is further needed to prevent potential harms of wrongful generalization. Okay, this is my 10 minutes talk, and thank you for your attention.
Thank you, Dr. Chiou, for the informative presentation. Thank you so much. And our next speaker is also from IIAS. Dr. Chuan-Feng Wu serves as an associate research professor at IIAS and a joint appointment assistant professor at the Institute of Health and Welfare Policy at National Humane University. And now, ladies and gentlemen, please welcome Dr. Chuan-Feng Wu, who will be talking about the ethics of algorithmic nudging. Welcome.
Thank you. I'm very glad to have this chance to talk with you about the ethics of algorithmic nudging. And it is still a developing project, so I will just share some of my very initial ideas about this topic. As we all know that nudge has been theorized research and test and of behavior intervention, and it has been widely used in not only policymaking but also in business. And as defined by Tsing and Taylor when they first developed the theory of nudge. Nudge is defined as any aspect of the choice architecture that alters people's behavior in a predictable way without forbidding any options or significantly changing their economic incentives. And we can find out that in addition to regular nudge, such as personalized default options or choice engines, along with the development of information technology such as big data, deep learning, or artificial intelligence, we can find a new type of nudge has been developed, so-called hyper nudge, or algorithmic nudge, or digital nudge. And according to Yang, who actually tried to argue there's a different kind of nudge in 2017, she argued that the hyper nudge is a nimble, unobtrusive, and highly potent, providing the data subject with a highly personalized choice environment, relying on algorithmically determined correlations, dynamically configuring the user's informational choice context in ways intentionally designed to influence decisions. And we can find out that there are three very important main features of hyper nudges. And the first one is the dynamism. Regarding dynamism, it is related to the real-time personalized feedback dynamic. The feature is enabled by the unobtrusive real-time collection, combination, and analysis of big data drawn from multiple sources. And due to the algorithm or the AI's one-to-many capacities and the personalization, we can find out that the application of hyper nudges can be used in policy making, and which can focus not only the general public, but focusing on specific individual in the general public. And regarding the predictive capacity, we can find out that the hyper nudge is constituted by algorithms that learn from the collected data and make behavior predictions. So unlike adjustments of a regular nudge, which is time-consuming, a hyper nudge receives immediate feedback about the effectiveness of its interventions and is capable of immediate adjustment. And third, regarding the hiddenness, we can find out that even though nudges are not immediately detectable, but the regular nudge are and should be visible in the physical world. But hyper nudge is different because hyper nudge are hidden in a more complicated and sophisticated way because all the information are collected, analyzed, and used unobtrusively in online information environments. Therefore, people would easily overlook the choice architects behind the hyper nudge. And due to the three features of hyper nudge, we can find out the ethical challenges of hyper nudge is different from what we face regarding the regular nudge. The first one is the uneven nudging power. It means that the nudging power is not fairly distributed in the information society. We can find out that the government is capable of obtaining more real-time personal data unobservedly than opposition party or the civil society through the implementation of varied policies. And the concern holds when technocrats use heuristics or nudges to create selfish outcomes and undermine democracy. So when the government who can gain this kind of detailed information and the big data, more refined nudge strategy then can be developed without proper monitoring in the name of policy analysis and transferred into a tool of social control. For example, like the social credit system developed in China, the government argued that they can use this kind of system, offer a tangible choice architecture, and is able to nudge and steer activities. But we all know that this kind of system is very arguable, and there are lots of controversial issues when the Chinese government try to use this kind of platform. And the second challenge is the heterogeneity. Because the nudge involves predefining what is net benefit across population being nudged. However, due to the complexity and the heterogeneity of individual values and beliefs, it is difficult to identify. And this issue may become worse in hyper nudge. Because hyper nudge are generally hidden in more complicated and sophisticated way, I just mentioned in the information society. And because most users are not aware of hyper nudges or the rationales behind hyper nudge, and they are not aware integrated in most of the online informational environments. In this case, hyperknowledge may inappropriately treat heterogeneous values of benefit homogeneously and restrict individual autonomy. And the third challenge is autonomy burden. Because hyperknowledge, no doubt, they are knowledges and do not mandate or ban options or significantly change economic incentives. But there are very main difference between the regular knowledge and the hyperknowledge is that the default option of a hyperknowledge is always to nudge. Because the character of hyperknowledge is that it is dynamically change their feedback. So when an individual, they try to turn down the recommendations by a regular nudge, they just opt out. It will be okay. But for hyperknowledge, the problem is that when I try to opt out a hyperknowledge system, I try to not to accept the recommendation proposed by a hyperknowledge. The hyperknowledge will receive the information and immediately give another recommendation and the feedback to the individual and try to recommend another nudge to an individual. So it's very hard and very difficult for an individual to opt out the hyperknowledge unless the individual who opt out entirely of the hyperknowledge. But the problem is that it is impossible for an individual to opt out entirely of a hyperknowledge because in an information society. So it then will significantly increase the burden of avoidance and restrict an individual's choice. And the final, the next challenge is social inequality. In hyperknowledge society, information, education, and differing social classes determine who the nudgers and who the nudged are. Therefore, obscure hyperknowledge in policy-making process may create a vulnerable group in an information society with subtle vulnerableness which are not easy to observe. For example, we can find out that educated and uneducated may react differently to hyperknowledge. It is because that the educated own more information or has the capability to access more information and therefore is more likely to perceive the government's use of hyperknowledge and choose differently. But the uneducated may not have the same capabilities to do the same. So hyperknowledge enables nudgers, such as the government, to ponder the simple, uneducated citizen who is neither aware of nudging strategies nor able to oversee the tactics used by the nudgers. And I think I'm here not saying that we should abandon hyperknowledge totally. I'm just saying that when we try to combine the information technology and the nudge, there are lots of issues we need to consider. And for example, like the transparency, like the accountability, or like experimentation. We need to consider these important mechanisms before we actually try to implement the hyperknowledge. And this is my presentation. Thank you.
Thank you, Dr. Chuan-Feng Wu, for your informative presentation. Thank you. And our next speaker will be Professor Ching-fu Lin from Institute of Law for Science and Technology at National Tsinghua University, where he teaches global health law, artificial intelligence law and policy, introduction to law and technology, and international law and global governance. So welcome, Professor Ching-fu Lin.
Thank you. Good morning, dear colleagues, dear friends. It's such a pleasure to see many old friends and to make new ones. I'm so happy to share with you part of my research on algorithmic transparency. I know I only have 10 minutes, so I'll be quick on the substance of my presentation. So we have witnessed a rise of AI application and developments due to the advances in machine learning, deep learning algorithms, availability of big data, quality data, and also the rises of computing power. And this rise of AI is also accompanied by different waves of initiatives in AI ethics, AI governance, AI law and policy. So we see many different initiatives in AI governance adopted by governments and by private sectors or international organizations. And there is a common theme among others, which is transparency and explainability. And then what do we really mean by transparency in terms of AI, or what do we mean by algorithmic transparency? At this moment, at least, we commonly agree that it's connected to other values. It's a prerequisite and also an enabling mechanisms for the realization of, say, accountability or AI fairness or AI trustworthiness. Without proper levels of transparency, it's really challenging for us to achieve anything like rule of law, due process, non-discrimination, etc. But then having a high levels of AI transparency requirements can also go into tension with other values like efficiencies or accuracy in the application of AI. So the question is really about what do we mean by having transparency or algorithmic transparency in terms of AI application and developments. If we don't see transparency as a binary kind of requirements, and we should require different kinds and levels of transparency in different contexts, as Wen-Tsong mentioned, giving a very great typology on the explanations, right? So if we have different kinds and levels of transparency, when and what kinds of levels of transparency should apply in what context, and or for what kinds of consequential decision-making process. So I try to divide the decision-making process into conventional decision-making and also algorithmic decision-making. So in terms of conventional decision-making, we have decision makers based on laws, facts, evidence, etc., all kinds of information, and then render a decision that affects subjects with legal rights and obligations. And then the subjects can challenge and appeal this very decision based on the reasoning and also the explanation offered by the decision maker. And that kind of transparency is the very basis for such challenges. But then in terms of algorithmic decision making, we have problems in terms of how to challenge and appeal this decision, because we have different levels of black box. Frank's paper and also books touch upon many different types of black boxes, right? We have legal black box, which is all about transparent trade secrets and the proprietary nature of algorithms or algorithmic decision-making systems. We have technical black box, which means that even if we force them to open up their algorithms, their source codes, for some algorithms, machine learning or deep learning algorithms, especially, it's also very difficult for ordinary people and even engineers to understand the whole logics of decision-making process. And then we have epistemic black box, which is about scientific and technology literacy, which also touch upon what kinds of explanation is meaningful to a specific group of population. Not to mention with other psychological anchoring effect, public and institutional pressure that force you to be submissive to the decision made or suggested by machines or AI systems. So I try to give a very preliminary mapping of what types and levels of transparency we should render or require depending on the types of black boxes that we aim to address, their risks and different stakes in terms of ethics and law, human rights implications, and the context of the consequential decision-making process. And also, in many other contexts, power asymmetry, remedies available, and the nature of the users involved. So we can have high level of transparency to the levels of having concrete and substantial explanation before or after the decision is made. We can also have personally and individually actionable counterfactual explanation after the decision is made. So we really need to think about the different contexts and examples and also the risk and the stakes are involved in the process, and given them different requirements and different types and levels of transparency. I don't think I have time to go through this kind of typology, but my main point is that we don't have a one-size-fits-all transparency requirements and explanation. So along the two lines here, in terms of the levels of transparency, timing of transparency, we can see different arguments have been tabled and also adopted by other scholars and also governments around the world. But then, not surprisingly, but interestingly, we see there has been a kind of regulatory carve-out, kind of embraced by corporate actors and some governments. We can see this in the UK's National Data Authority. They are actually embracing this kind of formalistic or superficial ideas of transparency, focusing only on giving you a nutrition label of AI or data set kind of facts. And this kind of fact sheet governance is formalistic in many ways. It kind of settles within universal ideas of transparency, giving you simple ideas on the basics, numbers, and also kind of data involved in the whole process without really engaging you with the potential risks and the stakes and the consequences of the decision-making process. And then try to avoid the very difficult and challenging ideas of explainability or other levels and kinds of transparency. And then, so with this regulatory carve-out, we're actually missing the idea and also the ongoing debate on substantive transparency and reasoned transparency. And I would like to emphasize that this kind of disconnection between transparency and explainability is actually happening in many regulatory initiatives in different countries. And it risks the ideas of just focusing on the formalistic idea of transparency, like giving you some basic information, kind of focusing just on risk communication with the users and those affected, marginalizing the aspects and different methods of transparency. And by this kind of universal fact sheet governance, we kind of systematically ignore context and social construction of transparency. So the other day, I chat with ChatGPT. I asked them what they mean by, I cannot play this, but I asked ChatGPT what algorithmic transparency is, and they gave me two different answers on algorithmic transparency. So my main point here is, yes, it is still challenging to navigate around the idea of transparency in terms of different levels and kinds of transparency, and it's really challenging to settle or put transparency into context, and not to mention put into concrete legal requirements. But yes, it's really it's still early to settle with formalistic and superficial ideas of transparency as fact sheet governance. So with that, I conclude my presentation. Thank you.
Thank you, Professor Ching-fu Lin, for the presentation. And thank you for all of our speakers' presentation for now. Later on, we will have a panel discussion after the break. So, ladies and gentlemen, now we will take a 10 minutes break. Please come back at 10:50 for the panel discussion. And I know most of you are feeling cold, right? So get warm up a little bit and come back in 10 minutes for our next panel discussion. Thank you so much. Ladies and gentlemen, our next session will commence shortly. Please kindly take your seats. Thank you. 各位贵宾，我们下半场的人工智慧伦理与法律国际论坛即将开始，请各位贵宾尽速就座，也请在场外的贵宾帮我们尽速回到现场，谢谢。Ladies and gentlemen, welcome back to the International Symposium on Ethics and Law in the Age of AI. And now we will proceed to the panel discussion. So first of all, I'd like to welcome our moderator, Professor Ching-Yi Liu from Graduate Institute of National Development, NDI of National Taiwan University. Welcome, Professor Liu. And now I'd like to welcome our panelists, our 5 speakers, again, to be back on stage. First of all, Professor Frank Pasquale at Brooklyn Law School and Associate Professor Julia Powles at University of Western Australia Law School, and Dr. Wen-Tsong Chiou from IIAS, and Dr. Chuan-Feng Wu also from IIAS, and Professor Ching-fu Lin from Institute of Law for Science and Technology at National Tsinghua University. Welcome our moderator and our panelists. And now we'd like to hand over the floor to our moderator, Professor Liu.
Hello, can you hear me?
Yes.
Yes. Okay. Welcome back to the panel discussion section. In this panel, I think I'm going to do the following things. in the first part of our conference, every presentation from each of our prestigious speakers has covered many different but related issues about AI's current and prospective uses and their impacts on our society. And each of them has actually proposed some kind of remedies. So I think we should discuss further about a lot of the impacts and the remedies. So to facilitate this dialogue, I will first, before I open the floor to our audience, I will first ask each of the speakers to maybe take this opportunity to raise 1 or 2 questions to any of the speakers, okay? To facilitate, to communicate and facilitate, our exchange of ideas, okay? So, Frank, you first? Yeah.
Sure. So, I mean, I thought this were just such thought-provoking presentations. And I guess my first question is, and I guess maybe I'm doing the same thing as Professor Liu in this role, but I was interested in how the approaches of Professors Chiou and Lin, oh, thank you, how they either complemented each other or were in tension. And I was wondering, when you were listening to each other's talks, I mean, in terms of the categories of explainability that you developed, Professor Chiou, and the diagram of explainability that you had, Professor Lin, what was did you have a sense that these were parallel projects? They were projects that were sort of necessary conceptual foundations for regulation? Or do these projects actually lead to particular regulations in the short term?
I thought you wanted to collect all the questions.
I think we can do it one by one. Yeah.
Okay. I think my typology is compatible with what Ching-Fu just proposed, the matrix, and at least I think my proposal about the external explanation can be complementary to what Ching-Fu mentioned about the upper 2 categories of his substantive explanation rather than the formal explanation. And in terms of the policy realization, I guess it has to be coded in some real life legislation, either in the data protection law or another special law regulating the AI in general. So that's my response to Frank.
So thank you, Frank. Yes, I do agree that my project goes hand in hand with Wen-Tsong's project in terms of giving a kind of holistic idea of AI policy, especially in algorithmic transparency. Like the typology of explainability is kind of one part of my matrix, right? Like a higher level of, I see this as a higher level of transparency, ex post or ex ante. But then in terms of policy making, I do see that pushing for a global and stringent requirement on explainability somehow backfire a little bit, kind of scare governments around the world a little bit, so they kind of dodge the idea of full explainability while admitting that it's very challenging technically or legally speaking. So they go for like the so-called superficial and formalistic idea of transparency. So I do think that we need some more nuances and also contextual analysis of transparency / explainability so as to support a mutually reinforcing kind of narrative in the future.
Okay. Frank, do you have any more questions? Perhaps for Chuan-Feng? No? Okay, maybe later. Julia?
I'll ask one on the hyper nudging. So I'm curious, in a context of a corporate development of hypernudging, how one could consent. How would you deal with that challenge of what would need to be disclosed in order to consent, because it's so adaptive? And my other one for on the final presentation, I can't remember, Ching-fu, you had this particular concept about how we are sort of lured into AI systems. I can't remember what particular expression you had, but it was an idea of sort of the inevitability of AI systems, and you had an interesting formulation, and I just wanted to get you to talk about it a bit more. It was in the bottom right of your slide, on one of the last slides.
I think the question is very interesting because in this presentation, I mainly talk about the governance nudge, but I think it should also apply to also in, like you just mentioned, in big tech, because the problem is that we all suffer, or we all under the influence of the hyper nudge of the big tech, and the problem is that they don't explain how they implement the nudge, how they develop that, and what kind of rational behavior the hyper nudge. So people actually, even we consent when we try to, for example, like download the app, but we don't exactly know what they try to do and what they try to do in the behind. So I think the transparency and the explanation is very important to explain to the general public what they try to do. But it's related to another question I also want to ask you, because that when I try to do this kind of topic, the problem is that the big tech always argue that it's trade secret. It's kind of their responsibility is to the general public, not to, responsibility is to the stakeholders, not to the general public. So I am very, I agree with your idea to say that it's important to change the traditional ideas of regulation to a new idea, because the big tech has tried to use different kinds of channels to use the big data or use the AI. And, but I still try to figure out how to use that. So I am very impressed by your proposal of the combination of systems and the intention. But the other one I try to figure out, because I try to do some research before regarding the pharmaceutical companies' responsibility. But the problem is that they might argue, especially also in Taiwan, they try to argue that the systematic error is not their fault. So they try to argue that I am not responsible for the systematic fault. And it should be, the big tech's responsibility is only to follow the laws formulated by the government. They don't have any more responsibility about that. So when you mention about the hyper nudge used by the big tech, I think these kind of challenges need to be overcome. Yeah.
Thank you, Julia. So were you referring to the idea of how human can be submissive to machines? Yeah. So I you know, my view actually comes from the idea of human machine interactions, because we know that, for example, in GDPR and in many other like policy initiatives, we are very happy to just ban like the fully automated decision-making process, right? But it's really tough to touch upon the idea of human-machine collaboration in terms of decision-making, because we give the final decision-making power to human, but at the same time ignores the possibilities of how they can be psychologically anchored by the predictions or suggestions, right? And we, just think about how we are submissive to calculators. So how do we have the kind of incentive to challenge, decision-making suggestions by the compass system, like criminal justice risk assessment system, given that we have a lot of caseload and we are busy, and we just tend to just go with the machine predictions and suggestions, and not to mention other public and institutional pressures coming from that kind of prediction, because as plaintiff or defendant would say that, judging from the predictive algorithm, I will win, but then why did you give me a different decision? So with all these kind of psychological anchoring effect, institutional pressure, I doubt that there will be a very, say, mutually reinforcing relationship between human and machine in terms of their collaborative decision-making process.
Okay, thank you. Maybe Wen-Tsong.
Yeah.
Yeah.
Okay. My question is for Julia. You mentioned about the big tech liability and trying to hold them responsible. I totally agree with your suggestion. But how about this small startup company, which may be the major players in Taiwan of the AI industry? Because some would argue that if we impose too much legal liability, then their innovation will be, well, stifled or destroyed entirely. So what do you think about, do we apply the same rule to the small startup company, or do they need different rules?
So I might take this in conjunction with the other very useful questions and comments. I think partly by going through the mode of, through the court system is one way to this. So it is actually a very familiar, these two responses. Trade secrets as one level, we are not required to disclose, and then if you regulate us, you'll regulate the small companies. From a regulatory perspective, I think there's actually been a lot of development in the digital markets, digital services context to recognise that there are different obligations that correspond to size. And actually it's starting to be codified in Europe and other jurisdictions where once you reach a certain size, you have more obligations. So I think we can carve it out, and we must carve it out, because the end game of a lot of these small companies is to be purchased by the big companies. So if we permit, and I think Clearview AI is a good example, permit an entrant to scrape information or evade the law, then we'll effectively be doing it in a runway for the larger company. So I think from a regulatory perspective, we can tailor to size. The common law response, I think the argument is well put about we only follow the laws put by government, which is why I think some of the opportunities are in mobilising other domestic laws. And in climate change litigation, this has been a strategy to say, well, we can actually bring an action under tort law for the obligations that a country has for future generations, for example. The trade secret one, I have been long exercised by this. So I worked in the World IP Organisation with Dr. Francis Gurry, who wrote about trade secrecy, and it's been sort of the model for the last 30 years in the international system. And I think that the use of trade secret by these companies goes well beyond what a legal trade secret is. Their definition of a trade secret is everything under our roof is a trade secret. And the definition of a trade secret is actually legally a much tighter notion around ideas that have the obligation of secrecy, that are maintained in a certain way, that I think go well beyond something that has these sort of consequences that are documented. So I would challenge some of the trade secrecy claims. If they couldn't be challenged, I think then the response by the state is, well, there are many, and the pharmaceutical analogy is useful, many other industries where there are sensitive pieces of information, and we don't just have a binary, it's yours or it's everyone's. I think there's an intermediate ground of, as Frank argues, around partial transparency, so that you could disclose those systems in a way that they can be audited and accounted for. The final one, just to the Ching-fu, the comment about sort of following the machines. I think Professor Chiou shared the example of, if I may share, your partner being so loyal to the GPS that he'd even drive into the ocean. And I think we sometimes have this, one of the great challenges for education is I actually think many technologists are aware of where systems break and how we are able to remind ourselves. And I wonder whether one of the things we might design into our systems is more things like what contemporary cybersecurity training is that in large organisations, they test their employees on a very regular basis to make sure that they're looking for phishing attacks and so on. So we show the flaws of our systems to us to remind us that they're guides to behaviour and not to follow them all the time. And I think that if we introduce those as that people are looking out for systems and the bugginess of systems, I think we'd save being so submissive to them.
I think I have to ask my question to Julia when I answer the questions, but may I? So I can ask another question, right? Sure. So maybe I have another question to Ching-Fu, because when you mentioned the transparency, when we talk about the informed consent, it's also related to transparency, because you need to get all the information so you can know what the big tech has to do. But when we deal with the informed consent, it's an old question, because how much information you should get, because too much information is like no information. So when we talk about transparency, especially in the AI age, the information is more complicated and professional than the regular information. So how do you react to those kind of challenge?
So thank you. It's $1 million question, I would say. But then giving an explanation and receive informed consent would be treated as like the ex ante transparency in my metrics. I do think that it touches upon the audience that you are aiming at, and also the different consequences of the decision-making process. So the GDPR, and I think that Julia also mentioned that a little bit, focus on the kind of meaningful explanation of the logics involved in the decision-making process. It's a very general and subject to different kinds of interpretation, yes, but then it's also helpful in terms of designing specific way of transparency or explanation where we target different audiences and consider different contexts and consequences of decisions. Just a very quick.
Thank you. So, Ching-Fu, now it's your turn to ask questions.
So, I am fascinated by Julia's talk on corporate accountability of big tech, and I do have one question for you, because I see this as a critical but missing element in the current debate on AI policy and governance. My question is, moving forward, how would you envisage a policy relationship between the government and the private sectors, because we see they are having an increasingly intertwined relationship, right? For one, the government is relying on the private sectors to develop and apply AI or automated decision system, because the government itself is not super able to develop one themselves. So it's kind of relying on the private sector. On the other hand, they are kind of contesting because they are, on the one side, regulators and the other regulatees. So how do they kind of interact with each other so as to kind of facilitate a healthy policy relationship? And relatedly, people are also arguing for a kind of public-private partnership in terms of giving solutions to AI governance, right? So giving that kind of complex and intertwined relationship between the government and the private sector, how do we kind of move forward in terms of corporate accountability?
That's many questions.
Yeah, it's a wonderful question. And I think the coupling of the public and private sector, I think, is some opportunity, because the obligations that rest with under public law grounds with government can therefore extend. But some of the ideas, I was just thinking about in your presentation on transparency and this risk, that the flexible ideas are always interpreted in their sort of most cynical form, is the risk. But in other industries, so I wonder if we need something like pharmacovigilance work is to ensure that the disclosure around pharmaceuticals meets a certain threshold. And there's independent entities, same with food safety. So there's the function of the regulator the regulatee, and then there are independent organisations, and the competition and the threat of the regulator acting means that there's a market and a profession around people who work in safety, and that they must be independent. So the auditing of the internal teams that do food safety and that do drug safety work is something that they need to meet thresholds, their standards, but there's always this risk that the regulator will do it. Even in most instances, they actually don't do it in a more robust way than the auditor, but the prospect that they could is there. So I think that it maybe is to create that third market, which is the auditors that preserve the interest of the regulator and the regulatee. And one way you could do that is through the procurement mechanisms that at the moment, I think our states take on too much of the risk. So they, in feeling that they need to be partnering with industry to provide these solutions, they don't put appropriate safeguards, I think, or appropriate expectations. So if those expectations were that what is provided is audited according to standards of transparency, that professionals who engage with all of the ideas that we're talking about, that you sort of have the pride of that profession matching then the obligations of both the private and public sector. So I think it's maybe that we haven't yet evolved those institutions, and I think we need some of these challenges around culpability to either be sort of standing in the wings, and there are some cases that are really live now across the world, so that you anticipate and then develop more of these mechanisms. Great question.
Okay, great. Thank you. Is there any further responses to any of the panelists? No? Okay. Then I'll move forward to our Q&A section. And I'll just ask anyone in the audience to raise their question. Okay, shoot, please. Yes. And then Professor Jen, you are the second one. Okay. 好，没关系，那个你们谁要先都可以，无所谓。Yeah.
Hello, I'm currently, my name is Hongxuan Shan. I'm currently assistant by Professor Liu at National Taiwan University. And I have a question for Professor Pasquale, because in past years I majored especially in social welfare law in Germany. So I'm so curious about how the administrative proceedings by granting of the social benefits. So I have two questions for you. For one, I'm very curious about whether we can actually distinguish between the benefit granting with benefit refuse. Because in the course of investigation of the facts, you should look at both things. So for example, in our Taiwanese social assistance law, if you have to apply for social assistance benefit, you have to prove that you are in a desperate situation, but also to see if you live with other family members who have responsibility for you, for making a living. So I'm really not sure if you, in the course of investigation, if we can, AI just neglect the positive requirement of the legal requirements, or we just see the positive sides. For me, it's not very easy to distinguish both things. And the second question is, you mentioned the advantage of AI in the field of social welfare law, but in most cases of health law, the first decision is made by the hospital or private sector instead of the administrative agency itself. So, but of course, for some other fields, for example, in social assistance law, the first decision is made by the government. So, should we differentiate the two situations? For example, if the situation is made by the doctor or the hospital first, how could the government encourage them to adopt this system? Because it costs a lot of money and also a lot of cost. And also for the patients, they would choose which would be the best for them. So they may cause some photoshopping, some concerns.
Okay, great. Here's, well, may I add something? Here's a PhD in law candidate in Munich. Okay, and I think you are going to have your oral exam next month, right?
Yes.
Yeah, yeah.
Oh, wow. Well,
So-
good luck. Yeah. Yes.
Yeah.
Thank you.
Given the quality of that question, I'm sure you'll be fantastic. So it's an excellent question. And I'll start with the first one. And I mean, I particularly appreciate the fine-grained, on-the-ground, practical aspect of what you're asking in both questions. The first one is a very difficult one, particularly because I think my case study, I gave myself an easy case study in the sense that there's a binary, right? And I think that these systems are particularly good at a binary. Like, for example, they can tell, you know, up or down, or Chihuahua or cookie, or you know, the other examples that were given today. And as soon as you have sort of gradations, it becomes more difficult. And I actually just was at a conference, or I was helping organize a conference for the Journal of Cross-Disciplinary Research in Computational Law, where I'm a co-editor, on administration of French housing benefits. And it's fascinating because there are extremely complex laws and algorithms that sort of can either slightly raise someone's benefit, slightly lower someone's benefit based on when they have a child, when the child is born, how close their family members are, et cetera, all these sorts of things. And that I'd be very cautious about automating for precisely the reasons that you're giving, in terms of the inevitable mix of positive and negative characteristics. I think that, and perhaps, you know, the ultimate problem, and I think one of the reasons why I bring up this case study, I was inspired by Arvind Narayan, who's a terrific computer scientist at Princeton, and he's working on a book now on what he calls AI snake oil. And he, prior to that, wrote a textbook on or I think on Bitcoin. And I asked him, why are you writing about a textbook on Bitcoin, given all the problems with it? And he said, yes, I agree with there's so many problems, but it is such a fascinating failure, right? And so on some level, it may well be that my proposal, I'd be very happy if it was merely a fascinating failure, in the sense of, as we articulate why what seems on the surface to be quite a humanitarian proposal fails, that can illuminate many aspects of the system. So for example, one other critique that I think comes out of your first question is it really possible to develop a rank-ordered system of the most deserving person who got disability and the least deserving one, right? That could be the philosophical foundation of my proposal, which in turn is naive about the problem of incommensurability, right? If you take incommensurability seriously, you couldn't rank order all the people on disability and say there's the most disabled person and there's the least worthy person who still got it, right? And it could be that we want to resist a legal system taking on the trappings of the false objectivity of quantification. And so in some ways, you know, I think the reason why I like to present this in a more academic setting is because I feel like it's not something that I'm committed to advocacy-wise, but I just want to describe it and sort of get the responses. And I think in your second question, so your first question was on the inevitability of positive and negative information. The second one was about forum shopping. Yes, that would be a huge problem as well, right? And I think just to further undermine my own proposal would be to say that I tried to say that it could be given just to grant benefits, not to deny them. But of course, if there's a fixed pot of money, some people will be left out, right? And so on some level, we're sort of creating these parallel legal systems, and maybe we don't want to do that. Maybe we only want to have one legal system and one approach to deciding things. But I still think that, nevertheless, I believe that given the existence within the statute of compassionate allowances and quick disability determinations for persons with terminal illness, for example, or for other forms of severe illness, that there does exist either implicit or in some ways implicit in the statute and explicit in some regulations, a bifurcation, a duality between this group of people that just snap, automatically gets it, and others who don't. And I guess what I'm trying to do is I'm trying to isolate the application of natural language processing to that small group that should automatically get it in a very quick way, and only talking about granting and not denying. And in that way, if you look at my proposal, if you think about, like, and one piece of background I should have given is, the discourse on natural language processing and AI and administrative law in the US is very much like, full speed ahead, let's do it, we're falling behind Europe, we've got to do it immediately. And what my proposal in that context is, before you try to automate all sorts of administrative processes, only do it in this low harm, low risk area. So in a way, I'm saying, let's do a sandbox. Let's try it out in this very low harm, low risk area. As we do it, we'll get very smart commentary like what you just gave. And that will further refine us, our ability to apply these things, and might even lead us to sort of resist automation, as as we've heard in various presentations today, in some areas. So that would be how I would reframe it, I guess, is that it's not like I am pushing it, it's that I'm trying to redirect an existing push of automation and administration. So thank you. Yeah.
Okay, Julia, do you have any comments on the two questions? Okay, sure. And then I move to the question for Professor Jane.
Okay, today I learned a lot. It's a very great symposium. All the talk are very very inspiring. But now I would like to know that, because today you talk about the AI model and also the bias, but the model were obtained based on the data. So I think how to use the data is also one of the essential that comes to the model and the system. So I would like to ask some about the data, how, especially for Frank and Julia, what your country has any policy? Because like in Europe, they have GDPR, and so they kind of forbid anyone to use the data without the personal agreement. So you need to give very very concrete and appropriate way for them to opt in or about. But I don't know if how's in US and also in Australia. And also that there's also some of the thinking that okay, if some group they do not want to provide their data because of their privacy, then that means our model will not be able to see their data. So in another sense, in that case, for those they do not provide their data, they kind of be ignored by the AI model. So if we take it in this as consideration, so in that case, so when their data appear, then it will come to the bias or that will not take into. So in the long run, they might actually get harmed instead of to get a problem. So what do you think about these views? Thank you.
Okay, Frank, and then Julia, and maybe our three local speakers would like to provide some insight later.
I am so happy that you're centering our attention on the data, because I think that is foundational. And I think I have three layers of response in terms of the US potential regulation and potential litigation. With respect to litigation as almost a regulatory tool, I have a piece called Data-Informed Duties in AI Development. And in that piece, I describe how there are certain, if you know that your data is incomplete or not representative, there should be some forms of tort liability for that. So I used the example that I believe Julia mentioned in her talk that was about a lack of representativeness of skin types in a dermatology database. Let's say we're looking for melanoma, and it may well present differently in persons with different skin tones, that if you have a database that does not have a representative sample of your patient population, that could be a predicate for tort liability. However, the problem with that level of regulation or legal response is that the hospital can say, just having the database is better than just having a person look at it. So even if our database is defective in some ways, it's better than nothing, and therefore you shouldn't hold us liable. So then we have to go to the next level, which is either state or federal regulation of the composition of the databases. And two promising initiatives there are the National Institutes of Standards and Technology in the US is putting forward some guidelines for, say, facial recognition databases, because we see already that they have been proven to be inadequate with respect to minority members of the US population and often with women as well. The problem is particularly exacerbated with an intersectional combination of women and minority populations, which I think is a huge issue, and they're trying to address that. Simultaneously, there's a group, or there's an agency in the White House called the Office of Management and Budget, which has put forward data collection standards. And I actually just supervised a paper this term that talked about the need for diversity with respect to representation on Asian American data collection. Because it turns out that in the US there was a category in the census of just Asian American. But of course people said, well, there's so many different groups. There's Indian American, Chinese American, Japanese American, Vietnamese American, et cetera, Taiwanese American. There's this huge number of groups. And so trying to make sure that we have granular representativeness, I think is the next stage of this sort of data. And that's just one example, right? But it's an easy example with respect to census data. So I think that those, between the litigation, state level and federal level efforts to improve data representativeness, that's really important. But the problem comes down to one of accountability. And by and large, these are guidelines, and they're very hard to enforce. There's not really, whereas like with the GDPR or something, you can have a massive fine, And so I think that's where Europe is way ahead in terms of saying, even not only substantively, but also in terms of an enforcement level. But yeah, I think that question of data quality is a critical one and really is at the core of so much of AI debates. And I wish we had more statisticians involved, because I feel like we really need to have like statistician lawyers almost combine their expertise and say that it's not that big data just means we can get rid of statistics. In fact, we really need to know what is representative and what is not, what's accurate data and what is not. So thank you.
Okay, thank you. Thanks for the great question. So I might just take off the inspiration of the comment that Frank made earlier about wanting to resist a legal system that overemphasizes quantification. And so my two areas of inspiration potentially on different approaches, you've mentioned the European one, but I'll give two that are really homegrown in Australia. So one is around Indigenous data sovereignty. And this is, there's a global movement around this, but essentially a recognition that the data that has been collected on First Nations peoples has been marked by emphasising particular features that reduce Indigenous peoples to deficit in many instances, to disadvantage. So in Australia we have measures of lack of education, healthcare and so on. And the response of Indigenous data governance and data sovereignty is this does not represent us fully and does not represent us in a way that allows flourishing rather than deficit. And so Indigenous data governance is a response that says we are more than our data, and the best way to represent what more we are is to have the people that the information is about determine how it can be collected and represented and what else might be required. So I guess it complements this idea of when we go to different demographic groups to give sovereignty to the individuals who know most about the connectiveness. Also Indigenous data is also interesting in that there's a very strong sense of the collective, how this might be useful at the collective level. So our state, Western Australia, does not have a privacy regime, but just this last week has proposed to include a foundational idea around Aboriginal data governance and data sovereignty. And the contest will be, how do you take an idea that's so novel to a legal system that focuses on, as long as you have consent, you can trade any data, to actually reinforce ideas of ownership and sovereignty. And the second, and this is an unlikely addition to Indigenous data sovereignty, I've done a lot of work on collective bargaining about data rights in the unusual context of professional sport. And professional sport is an area that has a lot of data management, but they've innovated some really interesting legal protections. In particular, when athletes are monitored, that information can be used for their health and performance, but it cannot be used to make decisions about contracts and about the impact of on their career choices. So it reinforces that information can give us data can give us information, but to use it in decision making, you require different standards. And so I've been really interested in that area. Also rights to say we don't want to be any other employees and workplaces. We don't get measured on the inputs to how you do what you do. We get measured on what you do. And so they're just two interesting contexts where I think different ideas around data exist. And the one place where I think that they manifest in traditional data protection and privacy law is it's typical to have a requirement that data meet certain standards of accuracy, quality and completeness. And both of those first two are very well trodden. People have lots of ideas around accuracy and data quality. But we have much less attention to data completeness. And one way of interpreting completeness is, as Frank represented, about the number of different demographics that we must include. But I think another alternative is to think of completeness as, does this data represent the thing that it is trying to represent in a complete fashion? And if it can't, I think it doesn't meet that threshold. And it requires us to say most of the things that matter can't be measured. And so how do we deal with that sort of immeasurability of important things and then focus our attention to where it can be measured?
Okay, thank you. Does Chuan-Feng or Wen-Tsong has anything to add or comment? Yeah.
I think I can comment on that too. The data representation is an issue, but we need to distinguish between theoretical and the real problem. Theoretically, if anybody not included in the database, there will be a representation issues. But in if the size of the population or the database is big enough, I don't think that will create a real problem, only theoretical problem. But when it comes to the vulnerable group, when the size of the people are usually small, and if that as a group are not in the database, either because they choose not to participate in the opt-in regime or choose to opt out, that will create the real problem of data representation. But to conquer that problem, I don't think to take away their data privacy rights or autonomy is the solution. I think only through the social dialogue and the persuasion can really solve these difficulties, and that's my response.
Maybe I can respond to this question from another perspective, because I think Wen-Tsong just mentioned the theoretical and practical issues with the data presentation. My question is that in a case in Netherlands, the problem is that it's related to the social assistance, that the people who receive the social assistance, their data was collected by the government. So the government used this data, and they try to use the automatic decisions. They try to categorize these kind of people and to decide who can get the social distance and who cannot get the social distance. And they try to develop new guidelines. But people who receive the social distance, they didn't know that their data will be used like that. So they are cut off. So, but if they want to get the social distance assistance, they need to deliver the data. But they are forced to deliver the data and used by the government to decide if they are in the social distance or not, social assistance or not. So it's kind of harmful to them because they don't know why I deliver this data, because I think I deliver this data for social assistance. But then, because I deliver the data, I was cut off the social distance. So there's no communication there, there's no explanation there, and they don't know why the rationale behind it, and they have no chance to discuss that. So I think in addition to the representation of the data, another important thing is that how do you use this kind of data? And people have the privacy right, or they have the data control right of this kind, because the inference is not only end in the data per se, but also influence the following decisions. Yeah.
Okay, thank you. I think we can take maybe some more questions. Anyone? Yeah, please. You.
Hello. Thank you for a symposium. And my name is Ian, and my question could be a bit more philosophical in nature. I hope that's okay. I'm just wondering if artificial intelligence has any business in a system of governance, because I don't think because one of the presentation introduced the term black box, and I think it's pretty interesting, because the idea of a legal system is, say, I have to interact with this set of laws that will potentially decide whether I'm guilty or whether I will be the beneficiary of a welfare. And normally people are put in charge to make that kind of decision. And these are the group of people that have, I think the term would be legitimacy, in terms of whether they have the power over my life. And if I disagree with certain decision, I can always use the court system, and they have people like that to help me to go through a system. They're called the lawyers. And if I ask my lawyer why the court made certain decision and why did you use certain legal strategy, he can always take out the law books and say, well, flip through them if you like, if you have time. You don't have to pay me, you can represent yourself. And most people are advised not to do that because it's an arduous task. There's a lot of law books, and there's a reason why lawyers are paid really well. But the point is, you can always trace the legitimacy of the basis, the legal grounds of their argument in the court's decision back to a set of laws. This is a process that if you invest in time and effort, you can eventually understand. But if you put the system behind it, black box, and say you ask someone, how do you explain the algorithm, how the system is being assisted in a certain way by this black box? Can a person really understand what's actually happening in that black box? Because it kind of reminds me that during the housing crisis, the mortgage crisis, and they had a congressional hearing, and these Wall Street people literally just came out with these boxes of documents, and they admit to the congressman that everything here is designed to obfuscate what they're doing. None of these formula were supposed to mean anything. It's just designed to confuse people. So what's stopping a black box like that in the future if it were implemented in any way? That, to say it's just random garbage, some gibberish inside. And how is the common people going to know that the black box, the algorithm inside, was actually designed to actually fulfill its originally intended purpose? So in my personal opinion, I don't think any kind of lack of transparency should be in the government. But because people are naturally lazy, that's why Uber, despite breaking many laws, are now delivering food. And the World Cup, it's like they kill a bunch of people building a stadium. We cheer. So, but there's like a lot of examples that the public once had a taste of what the huge corporation can bring to the table. They will default to the convenience, and eventually protests become silenced, and what was supposed to be stopped by the public policy in the first place became commonplace. And I had Facebook, that after Cambridge Analytica scandal, and it's still around. It's lost a couple $1 billion, but still around. So, my question is, do you think instead of talking about how to better use artificial intelligence to help the government, maybe instead we should push for even more transparency and push the black box out of the system entirely? Thank you.
It's your question for every speaker?
If you like.
Okay, if you like. Okay. Frank, you first.
I mean, let me say that. I mean, as someone that wrote a book on the black box society, like I do totally sympathize. Like I think that and my book has the finance examples that you've given, and I've wrestled with this, and I do feel like that is a issue. I just want to play devil's advocate on two levels, and just recommending a couple of works. The principle, I think, is that in a just legal order, you're completely right to say that the personnel are offering explanations that are transparent and that can be rooted in the law and that are their best faith efforts to interpret the law. But I think if you look at like a book, Chris Slobogan is a law professor in Tennessee who's written about, Vanderbilt, who's written about a book called Just Algorithms. And his argument is that the US criminal justice system is so biased that it would be better if you used just algorithms to make certain decisions about, I think, prediction, about where to enforce the law, and about how long to sentence people. And as someone, I've written an editorial for the MIT Tech Review saying that this black box AI sentencing is terrible, but I really want to engage with the arguments. I think it's worth engaging with the arguments of Slobogan, because I think sometimes there may be situations where if you can document long-term bias by the persons in the system, and the option is to have the persons as they are versus an algorithmic intervention, maybe the algorithmic intervention helps things. So I want to be open to that possibility, at that very least. But I think it's hard to accept that possibility if you really are committed to and believe in the legitimacy of the legal system as it exists. And it seems as though the black box is just a convenience that is luring people away from the legitimate system. But I think overall, I really take your point. And I think that it's going to be critical to ensure, and I guess the other thing I would say is that I think it's going to be critical to train professionals in government to be able to use some of these tools to inform decision-making, but only to the extent that they understand them. And that I think that's going to be the real barrier. And I think that that may lead to what you called for at the beginning of your question, which would be an elimination of black box AI from government. It could well be that we shouldn't have it at all. And I think that, my sandbox idea is just in positive cases. If it could be confined to positive cases of granting benefits, then I still would stand by it. But if you think that that would ultimately lead to use of the black box in a more general manner, then I would probably back away from it and say I wouldn't want to see it happen at all. Thanks.
Okay, thank you. Julia?
Let me take your observation about laziness and convenience as a way in. So I think that we have substituted adoption, laziness, and acceptance of technologies, adoption of technologies for genuine acceptance. I think we're resigned to a certain status quo, but we haven't necessarily accepted it. But it's not just about technology, I think it's also about the legal solutions that we have. So we need the same friction and resistance that you're offering to the inadequate legal solutions as we do to the fact that we shouldn't accept particular platforms operating in a certain way. Just because they are useful doesn't mean we accept that full context. So I think there's something in, I have a research stream on challenging inevitability, which centres on convenience, the cost of convenience, and that those costs aren't things that we've accepted. They're things that we are resigned to because of the convenience. The response I'd have to your, does AI have any business in government, is I think it has business in two senses, and they've come through the discussion. The first is in if we use our AI systems as diagnostic tools, not prescriptive tools. So Frank said if we can document bias in human decision making, that would be a beneficial use of AI. And I think what AI can do that humans can't do is to look at a system level. So you can understand at a level we don't see ourselves, our own biases. That I think is an opportunity. That said, I think we also have created human systems, and it's documented in Virginia Eubanks's book, where the people who create the information that we would even be reviewing do certain permutations to it. So the data is, I'll take as a concrete example, in benefits contexts or in high sensitivity like child welfare, people who enter the data that we would be reviewing know the implications of the data they enter, and so they don't necessarily put in the data that's fully representative of the reasons why they made decisions. That's why it's always, in the reduction, we lose so much of the context. So I think it could be diagnostic to, again, stimulate further diagnostic questions that would probably be human questions. Why is it that we seem to have this particular result that seems inconsistent with other results? And then we might find, well, because that's the only way we could respond to this situation, we need to fix that. So first is diagnostic, not prescriptive. And I think the second is, again, Frank's sandbox idea. So if we had contexts where it's not practical or it's not working to make decisions in the way that our current governance structures do, that we test and prove and make open and auditable the processes that we're experimenting with, rather than population scale experiments as our first port of call with AI systems, that we have much more constrained and well-studied examples of potential AI use. I don't see those happening at present, so I share most of your analysis about the risks. But yeah, I think this is the thing that, if we proceeded in a principled and a slightly more restrained way like that, I think we'd actually preserve the long-term prospects of this technology, rather than the prospect of it being sort of consequential at scale in a way that takes away rights that we would then work for a long time to reclaim.
Okay, any responses from our local speakers?
Yes, I share with you all the critiques about the black box and the use of artificial intelligence in governance. But what we are trying to do is either to distinguish between what is more acceptable use, such as the diagnostic one or the beneficial one, from the one that we think is more problematic. And also, we are proposing the conditions for using those artificial intelligence in governance. For example, we ask for the human control and discuss how we can place meaningful human control over the artificial intelligence systems, and also how we can provide or demand for the explainability of the system, so that the black box will not become the reality of this system when we use it in the governance. So we are trying to put these conditions, put these restraints on the use of the AI system in governance, and that's what we can do now. And rather than saying that all kinds of AI system is not acceptable or it should be banned entirely, and because we also see there are some benefits of this system to inform us, to help us, and given that we are all lazy people. So anyway, do you have anything to add?
Okay, Ching-fu, yeah.
So a great question on whether AI have business and government, given its kind of lack of transparency. I do see this is kind of nested around the kind of efficiency narrative at the risk of AI bias, AI black box, etc. Again, from my presentation, you will see I'm a big fan of transparency, but I also see that sometimes transparency without nuances and different layers, in different contexts, may be overrated. to some extent, because I like the idea of chain of legitimacy, because we're not really running the government on full-fledged transparency, right? We have a lot of human decision makers exercising discretions without really giving you sufficient reasoning or full transparency. But given that we have some safeguards or some remedies available and some appeal procedures, we're fine with that kind of chain of legitimacy with a very not full-fledged transparency. So what I'm trying to say here is that context matters. So, and also transparency is socially constructed, right? So we really need to take into account the context, the audiences, and what's meaningful explanation or transparency for them. So I echo Wen-Tsong's comment that in some, less consequential decision-making process, it would be fine to have some sort of AI application within the government with little transparency, because not all the black box issues are evil or critical that we need to just prohibit all the AI application. Just we do need to take into account the context.
Okay, I think Frank has further comment.
Oh yeah, just to build on what Ching-fu just said, this idea of a sliding scale is really helpful too, right? Because we might say you could automatically decide whether someone gets a small fisher's license, like a fisher, like just a license to fish, in a pond for fishes. Like if that were automatically done, but then you were given a chance to appeal later on, that's a lot less worrisome than like getting social benefits or healthcare or criminal situations. And in US law, there's a case called Matthews v. Eldridge, which sort of formalizes that idea, that the higher the stakes involved, the more process is due, the faster the process is due, and perhaps building on this work, the more person should be involved, as opposed to it just being done automatically. Yeah.
Thank you. I think, yeah, Professor Xu, I think this one will be our last question from the audience. Yeah.
Thank you. First of all, I would like to thank all the speakers for the wonderful presentations today. I did learn a lot. And I would like to follow up on the question on transparency, because to me, sometimes when anything is totally transparent, it also leaves more possibility for the bad guys to attack the system. So how do we kind of, what would be the way to navigate around that? And my other question is, I was very intrigued by Frank's idea of automated grace. And I think the idea is really nice. And however, I do worry about, bringing in the kind of consideration for the consequence of your decision. And if it's, mostly beneficial, so it's a kind of a more kind of a better choice for automated AI decision making. However, sometimes the consequence or the risk of the decision can be complicated and can be not totally obvious at the time when we design the system. So for example, Julia's example of notifying the debt repayment, it sounds pretty, kind of innocent in the sense that it's just a notification, but we didn't expect that this may lead to human costs. So how do we, but on the other hand, it doesn't make sense to kind of think about all the possible consequences too much, right? So what would be the right guidelines for doing that?
So I think the questions are for Frank and Julia. Yeah.
I wanted to start with your first question, or the first part of the question about transparency leading to vulnerability. I really like that because I do think that this is going to be a big challenge for these systems. So let's say that we do a transparency report on my proposal, and it says if you have these 4 illnesses, you automatically get benefits. That does create an incentive for a patient or an applicant to shop for doctors to say, oh yeah, you have this diagnosis, you have this diagnosis, you have this diagnosis, right? And that I do worry about. One response from Cathy O'Neill is interesting, and this is, I think, called the gaming problem, gaming the system in the US literature. Cathy O'Neill has argued that to the extent that happens, that perhaps these are fragile classifiers, and in that way that if a classifier can be gamed so easily, that then we might want to look into whether we use that classifier at all. And so then I guess the question becomes, would you add documentation requirements to say not only does the person have to diagnose you, but also provide the documentation for why they diagnosed you, et cetera. And so I think that there are ways of securing the system against vulnerability to gaming, but then they also they might create excessive documentation requirements, which might put us back to square one and lead us to not do the automated system and just do our classic sort of adjudication system. And I think your point also about the unanticipated consequences is a really important one. And it's something that would have to be built into the system, is to say, once you're classified as disabled, what are all the other classifications that occur? Because at least in the US context, one of the biggest problems we face is the collateral consequences of arrest and imprisonment. And there's a scholar I used to work with, Michael Pinard, that wrote an article in the New York University Law Review on collateral consequences of criminal conviction. And he counted, I think, at least 80 things that happen when you have a criminal conviction. No longer eligible for public housing, no longer eligible for student loans, no longer eligible for all these other things. And what I worry about, particularly given the Wild West of reputation creation that I talked about in the chapter 2 of Black Box Society, is that if someone's classified as disabled, to the extent that becomes public, does that feed into an employability database that might lead someone to have a low employability score? Because there's this report called The Scoring of America that says there's literally dozens of scores about people. The threat score, medication adherence score, credit score, all these scores out there about people that many of people know nothing about 90% of these scores. And so that, I think, is yet another aspect of the problem that makes it hard to answer in isolation. And I think one of the advantages of computer science, at least thinking about computational thinking in general, is its power comes from analysis based on very clear-cut, limited definition of problems and optimization. And yet, when we think about the real world, one of the last things you can do is make it a clear-cut optimization problem. So thank you for further complicating the issue. This is really helpful. Thank you.
Okay, Julia? So on the transparency one, I think in the two areas that I think that argument is most potent about gaming, I similarly was exercised by that in the two areas of cybercrime and national security. Two areas where the non-disclosure of the full workings is of importance in not knowing, essentially, being just ahead of criminals or security risks. However, from working in those domains, my abiding conclusion is that if there is no transparency, you have a different problem, which is massive threat inflation. So if nobody is doing the work of transparency, disclosure, audit and review, either in the national security context from oversight through judicial systems, and in the cybersecurity context, actually from the many people who work in information security as a sort of public service-oriented security networks, you then have a very significant problem. So I worked at the Cambridge Cybercrime Centre, where we worked on how do we get disclosure for research purposes so that we can verify the extent of the threat and risk and work on solutions. And it was remarkable to me that once that happened, the size of the threat reduced dramatically by that level of disclosure. So again, it's this, my position that you need something apart from the binary of things are completely closed or open, that you have partial transparency to skilled intermediaries. The second on unanticipated consequences, it's an opportunity for me to say one of the reservations I have about the idea of greater transparency and disclosure for more significant, the test in many legal systems is decisions of significant legal effect, or legal effect or similarly significant consequences. My great reservation about that is that we already are predicting that we know what consequences will follow, and therefore we're disclosing the information with that assumption. And my work in areas like professional athletes, which seems like an unusual context, shows that even decisions that aren't changing your legal consequences could ultimately lead there. And so the transparency requirement to have a threshold that we already can anticipate the legal effect, I think betrays your idea that actually there are many unanticipated consequences. So I would be very cautious of that sort of sliding scale idea. It's quite different, I think, in the allocation of, at the moment, registration and so on, which is occupying a significant amount of administrative decision-making time. But anything that impacts individuals, I think we should really think on what disclosure is required, and they will be the best determinant of what consequences might follow, and therefore have the tools to be able to agitate in response to it.
Okay, thank you. I think we are running out of time, but before we conclude, I would like to abuse my power as the moderator to raise my own question. Okay, as mentioned by our deputy director, that the Taiwan AI COE is, I think, is actually a result of our core value-driven policy making. Okay, so I would like to ask every panelist to elaborate your ideas about human-centered AI and or responsible AI. So particularly in connection with your presentation for today. Thank you. So Frank, yeah.
Yes. I think this core value framing is very helpful. And I think in terms, and human centricity is very helpful. Because I think we live in an era of almost a resignation to the post-human in too many academic precincts. And I think that sort of centering human experience, flourishing, and welfare is really critical. And so therefore, I think what I would say is in terms of how I would frame the fundamental human centricity is to view as much as possible human labor and human work as sites for investment rather than extraction, right? So we can look at someone who's doing a job and say, well, can we record everything they do and then make a computer or a robot that just replicates them, right? That's one way of thinking about it. And then, you know, we've solved that problem of the labor they're doing. But another way of thinking about it is to say, how can we help this person best understand and use technology in their job, in different roles in life that they play, to make them a more effective worker, citizen, parent, whatever it might be, you know, in any of these different areas. And so I think that, to me, is the ultimate human centricity, is to move beyond an idea of AI copying and replacing people and moving into an area where we're investing in people to be able to understand and direct and check the AI that's in their daily lives. Thanks.
Thank you. Julia?
I have a 4-word response.
Good.
For both human-centered AI and responsible AI. I think it's mechanisms for civic accountability. I think that's the core of all of this for me.
Yep.
And to the question, mechanisms for civic accountability. And I don't think any country in the world yet has that.
Okay, great. Wen-Tsong?
Although I'm all for the concept of human-centered AI, but sometimes the human nature tends to like to control everything.
It's true.
So in a sense, I think a human-centered AI should be understood in a way that we should curtail our desire to control and make use of the AI in that way. So, well, that's my alert to the human-centered AI concept.
Thank you. Chuan-Feng?
Yeah, I think I agree with Wen-Tsong with that. I also agree with the human-centered AI or responsible AI. But I'm thinking about another issue we need to raise is that how the society respond to this kind of human-centered AI or responsible AI is that the persons or the society need to be empowered. They need to know more know these kind of issues or these kind of rationales, because respond to the transparency issues. I think that in the early days of the physician or physician-patient relationship, we also argue that it's too complicated and you should not, we should make the decisions in accordance with the doctor or in accordance with the government. But when the patients are empowered, they are actually can play a more essential rules in these kind of situations. And I think when we try to discuss the human-centered AI or responsible AI, and the other, there are also lots of mechanisms need to be developed, and not only we just focus on that. Yeah.
Thank you. Ching-fu.
So I agree that human-centric AI and responsible AI are very useful framing, and also gives you a very general guidance in terms of policy building. But I'm a little bit skeptical about the kind of how operational the both framework can be, because when we talk about human-centric AI, what do we mean by human, right? It's individual to the individual level, group level, different populations, etc. And when we talk about responsible AI, responsible to whom, right? And how responsible? And these two frameworks can go hand in hand with this kind of inquiry, and I do see that there could be interpreted very differently in practice, especially in countries with different cultural and political underpinnings. For example, society with individualism or individualist culture or collectivist culture, they can understand human-centric AI completely differently. So
okay, thank you. Okay, thank you for all your ideas and elaborations. I think that will conclude our panel. Thank you very much. Thank you.
Thank you, our moderator and panelists for the wonderful panel discussion. And thank you so much. Please, well, this will conclude today's International Symposium on Ethics and Law in the Age of AI. And we'd like to thank you all for your participation today. And we hope the development of AI in Taiwan will go hand in hand with the law and ethics to create a better future for all. Thank you so much for joining us today, and thank you all again for your wonderful sharing. Thank you so much, and have a great day. Thank you. And I would like to ask, sorry for...
oh, good luck, okay.
Before you go, please, let's take a photo together on stage.